Title and Commerce, featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Saturday, August 21st edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology, and we'll do the disclaimer next.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Again, I'd like to welcome everyone to this Saturday, August 21st edition. Welcome to NTT as New Trust Technology. I'm going to go to the Q&A next. All right, we started the Q&A, so press star 6, star 1 to raise your hand and get in the queue line. Press star 6, star 1. State your name, where you're from. Press star 6, star 1. Michael, you're unmuted.
Can you hear me?
Yeah, go ahead.
Can you hear me now? Can you hear me now? Got a question for you. A hypothetical. Say that say that someone was had an issue with a police department or where the case may be, and they don't have any documentation whatsoever. Let me rephrase that. Say that someone died, and you went to get their body, and the other relative, because they don't recognize you being married to that individual, the relative's family came and got that individual out of, or it was released, that body was released to you. Now, you want to file a case against them, but you really can't because you have no trust res or signature. But the individual that was released to the mother had a issue in another state where they were released via through the police department of another state, because all states are sub-corporation of the main corporation. Could you use that other state trust res to go in and go after the initial residing state that you're in? You follow what I'm trying to say here?
Yeah, if I think I'm reading it right. Really how important to create the evidence or the records is, because if you don't have something, it's pretty hard to start, from nowhere.
Well, that's what I'm saying is that because it's all in one, all the states are under one corporation. Could you take the trust res from another state and bring that in as far as getting a trust res or the signatures to bring charges against the initial state?
Sure. You might have to come in through the, say, foreign judgments or foreign evidence, but yeah, once you've got a record in a foreign state, you could use it in some other state.
Okay. That's all I wanted to know. Thank you kindly.
All right. Anybody else? Press *6, *1, get in the queue line, ask a question.
Hey, Christian.
Gary, you're on.
Gary.
Hey.
I have a hypothetical for you since no one else is ready to ask a question yet. I'm sure Eric is thinking up some now. In this situation, let's say there's a piece of property that was part of a development put in, say, the 1950s. A plot plan was recorded in the county, and this particular piece of property bordered one of the roads in that development or subdivision. But through the years, this particular piece of property was never accessed because it was actually part of a larger piece, and the access to that larger piece was via one particular road. And in the ensuing years, it was parceled or partitioned where the only way to get to the, let's say, the back piece was down another segment of the road. And through the years, that particular segment of road was never utilized to access that piece of property. But at the end of that road, which was never part of the original subdivision, are some landowners that used that part of the road to access their property. And now they are claiming through prescription the right to close off that road and deny the property owner of that partition piece that fronts on that road access to their property. And they've never done anything other than...
Is property then going to become landlocked?
It would become landlocked, effectively, yes.
That's impossible. Equity would never allow that.
Okay.
That would totally take the use of the property, and it would become unusable and worthless.
And that would be a cause of action, denial of a right to use of property.
Yes, right.
Now,
yeah, I think if you on Wikipedia and you do a Google search for, or not a Google search, a Wikipedia search there for easements, and
right.
it's going to fill out to you all that you're talking about.
Yeah. Well, one of the things that you could utilize in the statutes of that state, not arguing the fact that it was landlocked, but going down the avenue of, if you do have a piece of landlocked property, you can put in an application to the county commissioners to have it, a road access provided.
Right.
And if you did go through that process with the county commissioners, which are a, I guess, quasi-legislative or enforcement arm of the local government, who has authority to serve the public, if you present an application meeting all the qualifications of that application, and the statute says that they may then proceed to acquire the property necessary to put in an all-weather road, which in this case would even be the same road, so it wouldn't cost them anything to effectively provide access to that piece of property. And let's say they denied to grant that access after having followed their rules and regulations or statutes. What could you do to that group of county commissioners using trust to force them to follow their own statutes and fulfill their office?
I'd have to think about that a little while.
I mean, an application would have been put in with a signature, of course, so that would be trust res, and presented for the purpose of them fulfilling their duties and obligations as public servants, elected public servants. And if they would refuse to fulfill their duties in that office and let the matter just die for lack of action on their part, would they not be a party to a cause of action?
So is there a statute and code that would be public policy that would be that they should do a certain thing to save that road? Say,
well,
something on the books that would that they would be in breach of that public trust?
What they would be claiming in this situation would be that it's not a county road because the county hasn't maintained it for the last 20 years. So therefore, we have no say over it. But in order to not argue that point in civil court, but instead go down the route of applying their statutes for the application to get access and not cost the county anything monetarily, they have failed to uphold their duties to even hear put the matter to motion to make a determination.
Some way to breach the public trust, then you can come at them under a public trust breach issue. But under equity, I can't see how, if this property is going to be, it had use of a road to get access, I can't see how equity would allow that road to die in effect so that it would become landlocked.
Yeah. Well, I think
you got issues going here. You got an equitable issue, and you got an at-law side issues.
Right. At law, it's slam dunk. But if you can't get the discretionary judges to give you a remedy at law, then you have to go at it in equity.
Yeah, no, I think that's probably the way you should go first, the equitable route.
Right.
And then we will come back in and give you an at-law remedy if it has to.
Right.
If you're in equity, you can't talk about anything at law. And really, that's what you want, because that excludes all of the statutes and codes and the public policy and the discretion, because now you're in the conscience of the court, where the conscience of the court can't allow this piece of property to become landlocked and useless.
And you take away the argumentative powers of the opposing attorneys.
Yeah.
No matter what they say, it's not admissible.
They can't. It's not in equity's position to argue at law.
Right. And as an addendum to this, on the at-law side, just to show how they would be even more in violation of their own statutes, let's say the previous, the property owner that's arguing about the roadway being private or public saw fit to get a quitclaim deed several years after the sale or purchase of their property from the previous owners, in which it stated that it was intended to be given during the sale but had not taken place, so they're doing it now. And then even on the quitclaim deed, they committed or broke the law through a notary by having a notary in one state represent themselves through an omission or through an error in the quitclaim deed, but nonetheless represented themselves to be a notary in one state while stamping it with a stamp from another state. and that would effectively make the quitclaim deed null and void. It's fraudulent.
Yeah, it would be, yeah.
So
that would be probably on the at-law side, though.
Right. So, like I said, on the at-law side, it's a slam dunk, according to the statutes, public policy, and issues with the notary. So, yeah, I think that would be the best approach, is to take it to equity and enter a cause of action for denying a right to property, landlocking the property, or through the landlock of the property.
Yeah, right. The Wikipedia site, I believe, has a case. It kind of discusses the same scenario.
And that was on what again?
Wikipedia.
I know.
Do a Wikipedia search for easements.
Easements. Okay. Okay. Sounds great. I think we're on
either, because I was reading it the other day, it was either, because I was doing research on real estate and thing, and I was doing research on easements, and one of those two talking about basically the same thing.
Yeah. Well, there's a lot in the statutes on easement that, you know, would be being violated here. But again, that's on the at-law side and up to the discretion of the judge, and they're going to interpret it however they see fit. No doubt they can find...
Well, that's where you got to go into equity and have an equitable hearing.
Right. Yep, that's kind of what I was thinking. We're on the same page then. All right, thanks, Christian.
Okay, Terry, appreciate it. Anybody have a question? Press *6, *1 to get in the queue line. Raise your hand.
You may now ask your question.
Hello.
Hello. Yes.
Muted.
I'm on the call. I was just wanting to ask for some basic background information, or probably should get into the for shared files and do some listening on some of the other audios I see might be available. I don't know if you care to give any background on your thought, your processes and methods, and where you're kind of coming from this evening.
Yeah, we've got a lot of information on that, you know, starting on 11/7 of 2009 on the For Share site forward. Any of those audios back in there in the early days there. Process.
Appreciate that.
Are you on Skype on the Welcome to NTT site?
I am. I'll check those out. Thank you.
Oh, right. Any specific questions, you know, on NTT?
No, this first day, so no, not yet.
Okay.
Thank you.
Basically, we just do payments with trust in merging titles and extinguishing of the debt. That's basically it in a nutshell. I don't like to use the word payments, but it's extinguishment of the debt.
Mm-hmm.
Acts like a payment that way.
Is it based off the U.S. trust?
The U.S. trust. Could you add a little bit?
Does the USA, the U.S. government, aren't all those entities underneath one trust?
Yeah, they are. Trust with we the people. We make a equitable asset merger with a debt title in the debt by the merging of the two. Debt is a minus and the asset's a plus, and when you put together the two, they cancel each other out. Extinguishment of the debt.
I see the basics. Well, thank you. I have some research to do.
Like key thing is how to create the records or the evidence, how to claim the titles, move the titles so you can merge them, create the evidence that you did that, and if there's any discrepancy, you can come in and prove that.
Titles for all property, real estate property.
All obligations or debts. Big thing is, with the other methods through the redemption or the debtor-creditor realm, creating negotiable debt instruments to do set-offs with, which are, you're creating a debt to pay another debt with. And in effect, what you've done is you've mounted debt up, you've multiplied or compounded it, you've added debt upon debt, and you've contributed to the problem. Although you may have fixed your immediate need, but in the end, it buries you. Because the problems we're all in is we've got too much debt, and we're swimming in debt, and debt is hanging us. In the end, you lose, even though you might solve your immediate problem. But with the trust, you merge the two together and you extinguish the debt, and that's the only way you can on the private side and get rid of the debt on the public side, through a trust.
And the technology is the mechanics behind merging the trusts.
The moving title platform, we use that to create the evidence or the records or the material fact that backs up what's done. So really, it's a far superior way to accomplish the end goal. All along, under the other remedies, we thought we were doing set off touching the private assets out of the trust, and we really weren't, because we really hadn't studied trust to see that. Benefits also in the trust. The trust has the burden of proof shifts to the trustee, and he's guilty and can't prove himself innocent unless he's got a record of a payment or a disbursement. Exactly how the courts today are getting us, but now it's reversed, and we're using it against them. So we're using the trust as a vehicle to reverse the whole process.
Mm-hmm.
Like you on Gorilla. Courts of equity. Another thing about the trust is that nobody in the trust needs to know that a trust is being formed. And that's the, I believe it's the second restatement, section 64. Second restatement, law and trust. That's the power of the trust. It's really a secret trust. Nobody even knew you were in a trust. He who claims trust must prove trust.
Mm-hmm.
But you never claim a trust, neither do you, so no trust really exists on the public side until you bring it forth. If you don't bring it forth, it still doesn't exist. So it's non-existent on the private side. So these are the basic things that NTT are superior under trust to any of the other remedies out there. We're really not getting a remedy, because remedy is on the private side, the public side, and relief is on the private side under equity. Equity is where trust, different law forms. Public side at law, and equity being under trust being private side.
I do understand those basics. No, I do appreciate you going back over that. I'm going to take my time and go through the material that you've already presented.
I said start that 11.7 2009. That's where we had NTT debut.
And you are referring to the audio files, sir, right?
Yeah, the audio files, yes.
Okay. Thank you.
Appreciate it. Thanks for coming on.
Of course.
Anybody else have a question? Press *6, *1 to get in the queue line. Dan, you're unmuted.
Hey, Christian, can you hear me okay?
Yes, can. Go ahead.
All right, this is my first time on my computer. I always join you on the phone, but now I'm on my computer, so I got a question for you, and I represent another beloved on in our family here, the NTT family, that is. Mortgage. When the mortgage is filed, the mortgage and the deed of trust are filed basically into the public, but the note is not. Why?
The note's your evidence that it was a trust and your payment, and they'll never prove your case for you.
Okay, so basically, the way I understand it is the note is no different than the check in our checkbook, and our checks don't get recorded to the public, just the way the note's not going to get recorded to the public. So if we can actually prove that the note was used as a check, that's going to give us a heads up as far as the mortgage and the deed of trust goes, correct?
Yeah, the note or the checks are really your equitable assets, but you're not claiming them to be equitable assets, and they're debtor creditor until you do.
Which is why we go in and we claim, well, we take a step back. We go back to the signature on the application. We claim that as being ours, and we're not at that point in time. We're not going to gift or give it to them. We're going to claim it as ours, and we want our future interests back as well. Correct?
Yeah. So we claim it on a UCC-1, but then we're also claiming it with restrictions. We're not going to give it freely or grant it freely or gift it freely. We're going to put restrictions on it. We're going to state a purpose with it, what it's supposed to be used for, a condition. That specific purpose, that special purpose, that makes it trust.
Okay, very good. Sorry if you can hear the loud noise in the background. My daughter found her lungs again tonight. Let's see. One of the questions on the main chat, backing up what I was asking, was that a deed of trust is actually a private agreement in the private, but yet they file the entire document into the public. But if we do that, we lose our trust. If we bring the private information into the public, we lose our trust. Why can they do that, but we can't? Isn't that a double standard?
That's the way it was designed. So they wrote the program, they wrote the contract, they wrote the play, and since you allowed them to write it, that's how they wrote it. By them taking the private agreement and making it public, they turned it into the debtor-creditor.
That makes perfect sense. They make the rules. They get to change the rules if they want to.
You know, they really don't get to make the rules. It's just that you granted them the authority to make the rules. So who really makes the rules?
We do, my friend. We do.
We do, yes. But you granted them the authority to do carte blanche, anything that they wanted.
So I guess a way of looking at it is when you go in and you create your indenture, you want to keep that private because, well, number one, it's a state secret. You don't want the other people in the courtroom to get confused on what's going on, so you got to keep that secret. But number two is you want to keep that information confidential so that they can't come through and steamroll your law that you lay out in your indenture. They can't steamroll over that with their own rules.
Right.
Okay. All right. Awesome. I'm picking this up, man. And to the last caller, the last caller, the new guy that you were talking to, one thing I'll say to you, my friend, is if you've been studying creditor at all, if you've ever heard about adhesion contracts, from my own personal study, a lot of the times what you find out that these adhesion contracts, you might as well just go ahead and call them adhesion trusts. And you're benefiting from a trust that's laid out there that you do not realize it's a trust, and since you're a beneficiary, you're giving up your unalienable rights and following the rights outlined in the trust indenture that you do not know if it exists. Am I too far off the mark on that there, Christian?
I'd say you're pretty much on, yeah.
Okay. All right. Fantastic. Thanks, man. I'm going to get back to my studies, and if I have something else come up, I'll hop on the call and ask you. Thanks, bud.
Okay.
Yahweh bless you. Bye-bye.
Press *6, *1 to raise your hand, get in the queue line, ask a question. Press *6, *1. I'm going to do a little bit of read here. This is out of the Florida and Federal Evidence Rules with commentary. This is an Aspen Publishers book by Peter Nicholas. On page 135, this is under Florida Statute 90.507. Now this comports to Federal Rules of Evidence, Rule 501. Florida Statute 90.507, this is waiver of privilege by voluntary disclosure. Waiver of privilege by voluntary disclosure. A person who has a privilege against the disclosure of a confidential matter or communication waives the privilege if the person or the person's predecessor, while holding the privilege, voluntarily discloses or makes the communication when he or she does not have reasonable expectancy of privacy or consents to disclosure of any significant part of the matter or communication. This section is not applicable when disclosure is itself a privileged communication. So now under the sponsor's note 1976 enactment, it says this section provides for a waiver of the privilege by voluntary disclosure, as the Florida Supreme Court stated in the leading case Saviano versus Luciano. That's a 1957 case. Quote, as in all confidential and privileged communications, the justification for the privilege lies not in the fact of communication, but in the interest of the persons concerned that the subject matter should not become public. When a party himself ceases to treat a matter as confidential, it loses its confidential character. Next, it says, recently in Tabliao versus Breeze, 1968 case, the defendant voluntarily testified in the disposition to confidential communications between him and his wife. In denying the husband's objection to the introduction of the disposition during the trial, the court stated, quote, it is clear that under the law of Florida that a personal privilege may be waived, and when Mr. Tabliao voluntarily and without objection testified on deposition to the privileged communications, they lost their confidential character. Next section. Waiver by voluntary disclosure occurs only when the substance of the privileged information is revealed. Thus, when a witness upon cross-examination testifies without objection that he has not made a certain statement to his attorney, he has not waived his attorney-client privilege, since the contents of the statement has not been revealed. That's Seaboard Airline Railroad versus Parker, Florida 1913 case. And another one they list here. And then next, a commentary on the federal and Florida rule differences. Florida Statute 90.507 provides that a person who otherwise has a privilege against disclosure of a confidential communication or document waives the privilege if the person or his predecessor, while holder of the privilege, voluntarily discloses the matter, makes the communication when she does not have a reasonable expectation of privacy, or consents to disclosure of any significant part of the matter. Next paragraph. Under the rule, Florida rule, The failure to object to the introduction of otherwise privileged matter constitutes waiver. See Woldell versus State, 2001 case. When disclosure is inadvertent, Florida law neither views privilege as automatically waived nor necessarily preserved, but instead follows the multi-factored relevant circumstances test to determine whether the privilege has been waived. See Abmar Housing Development versus Lisa Daly. So when a particular disclosure of otherwise privileged matter is voluntarily made, it constitutes a waiver of all other privileged matter relevant to the matter already disclosed. See Coates versus Ackerman, 2006 case. So anyway, I think I'll leave that last paragraph. You get the message. Anytime you bring in your private substantive rights into a public court or in any public forum, you waive the privilege and nullify it. You waive the right. And what you've done really is you've taken the private stuff and you breached the trust and you commingled it by bringing it over into the public, and now you fall liable for the statutes and codes because you breached your own trust by commingling, crossing public with private. So that was 90.507, which every one of the 50 several states has that somewhere comported in their own statute somewhere. But you could check out Federal Rules of Evidence, Rule 501, and that basically just tells you to go to your local state rules, look up in your local state rules, and you'll find something that I just read under some statute that you've got there under a point something 507, and it'll basically explain the same thing. But if you really want to get into some details on the evidence, get this book on Florida and federal evidence rules. Now, they also make one under New York and federal, and they also make one for Texas and federal. So you have three options, either Florida, New York, or Texas. Get whatever one which you want. It's not that expensive a little book. It's a little paperback, or it's not that much. It's an eye-opener. Okay, next caller. Jeff, you're unmuted.
Hey, Christian. Good evening. It's Jeff. How are you?
Hey, good.
What if it's the other case, the other way around, where the public officials or the public trustees are breaching your trust in public? They start talking about the trust in public.
Whoa, you got to object. If you object, then you preserve your waiver.
Yeah. So that way you can appeal it as well.
Yes, yes, you must object. If you don't object, you waive it.
Oh. Okay, that's good to know.
Whoa, wait, objection. That's an NOI. I object. That's an NOI. But now you got to have a reason why. Well, that's private. He's making public. We need a protective order here. I object.
Right. You have to have something, a reason. So yeah, it's a private matter. Is that sufficient grounds just to say it's private?
Yes. And if you need some more, tell them it's trust. It's confidential.
Yeah. And then I had another question. I've been reading. Is there any difference between a deposit for a specific purpose versus a deposit for a special deposit? It seems like there is a difference between those two.
Well, a special deposit is a deposit made for a specific purpose.
Yeah, so they are the same.
Yes. Now, there's two kinds of special deposits. One that was just put in to be kept safe and segregated, and another one was put in to be kept safe and segregated with a specific purpose. The latter
that's
one
I guess what my question was. Okay, for a special purpose, specific purpose. A specific deposit is a special deposit for a specific purpose.
Yeah, that's a special deposit. There's two kinds of special deposits.
Got it. Okay, that's pretty clear now. Okay, well, that's good to know. So if they bring it out into the public, then you just object. That's it. Period.
Yeah, but be prepared to back it up with an NOI, with an SOI. The objection is Why? Now you need an SOI to substantiate it unless they let it slip through. So you have to state some grounds to back that up. Why do you object? Otherwise, it'll time out and they'll clobber you.
Yeah. Got it.
You just can't object without a reason. The reason is the grounds.
Right. Kind of your intent or your purpose.
Now, the NOI is the claim. The claim is the objection.
Yeah.
I object. That's a claim. But you've got to substantiate your claim with some kind of grounds, or else it'll be overruled.
Got it.
You got to have an NOI and an SOI. That's basic. That's basic government.
Of course.
Which none of us know how to do.
So you just bring it back to your NOI that's already on the record, already in their possession. You just go back to your NOI.
There are many different NOIs. An objection is an NOI. Your claim, there's a trust, is an NOI.
Yeah.
There are many NOIs.
Right. Got it.
And then there have to be corresponding SOIs to support it. That would be the material facts, the grounds.
Yes. Yep. The evidence, material facts.
Yeah, it has to be relevant and material.
Yeah.
Be admissible. And it can't be private, or else it'll be waived. So there's the line.
Got it.
That's where the notices come in.
Yes. Keep it colorable in the public. And really, you never want to. The facts are irrelevant. The only fact that matters is they're doing banking, and we're here to find out where is the payment. That's it. The facts of the case are totally on the moon. Who cares about the facts? You don't want to talk about the facts because that's just assumptions and presumptions and arguing at law.
Yeah, you've taken the where's the payment under the debtor creditor, where they're asking you where the payment is, to where you've reversed it under trust, and where's my payment?
Yep. And we've already withdrawn.
Where's the completion of the trust?
Right. And our evidence is our records that we've withdrawn it from the general deposit, which is the debtor creditor, and had it specific purpose or special deposit, put it in special deposit.
Yes. Now, we have a twofold obstacle. Number one, we got to know trust basics.
Yep.
You got to be able to have the intent, purpose, party, specific trust, resident, method of formation. You got to be able to prove that. You got to create the evidence, that proof that you need.
Right.
That's one step. But then you got to know how to bring it into court. That's the next step. And as we've always thought before, that's where a lot of people are falling down.
Yeah.
They don't know enough about court procedures, process, and the forms.
Yeah.
And they're coming in with garbage.
Yeah.
And the court's judges and things are saying, hey, this is garbage. And they're right. It is garbage. Because you're not bringing it on a form that they're used to seeing. You're not doing the procedure and the process just the way they want to see it. And it has to be done to get yourself in the door to where you can open that second door into equity and get into equity.
Sure. Public pleadings versus your private stuff, though. You're basically separating the public color presentments versus the private presentments. And if the judge says it's trash, the private stuff, wouldn't he still have to rebut it? I mean, can he just make a generalization and say, oh, it's just trash? Well, can you rebut the record? Is there a record to rebut the record that, I have here?
Well, why do that? Why would I want to rebut it? With what?
Well, they can't. They can't rebut it. That's the whole point, is we have the evidence, we have the record.
Debtor creditor stuff. That's debtor creditor. No, I'm creating an argument. I don't want to create an argument.
Okay, that's what I
create an argument,
like.
And we got a controversy that the court just took jurisdiction, and then we're off on the at-law side.
Right,
Stay out of
okay.
that. No, I want to ask them, all right, you say that this is no good, this is trash. Now I want you to make your findings and conclusions and facts and law. Tell me the reason why so I can correct it. Do you know of anybody that asked the judge, what was the reason why you dishonored or told me it was no good?
Your findings.
I don't know anybody that asked the judge that. You got that right.
Okay.
So when the judge says, yeah, this is no good, you better believe him. But you got an opportunity to go back in and correct this now. Don't think that that's it, it's all done, it's over with. No, it's not. You probably got at least another 10 days to do something, but you sit around on your butts with on your hands and you do nothing, and then after the 10 days, after you got an order of a judgment out of there, you're dead. But again, it comes back down to you didn't know how the courts are operating because they gave you 10 days to go back in and put in a motion for reconsider or something.
Amend the pleading or, yeah.
But you just didn't know court procedures. You didn't know the process. You didn't know the rules of the court. So we got a twofold problem. Number one, you got to know how to create a trust and prove a trust. Number two, you got to know how to operate somewhat in court.
Yeah.
Now, nobody likes to say that I got to be an attorney, but I'll tell you what, this stuff is running your life whether or not you see it or not.
Sure. Absolutely. No doubt about it.
If the laws represent your rights and you don't know what the laws are, you have no rights. Now, why do you suppose they're keeping us from knowing what the law is?
So we waive all of our rights.
Right.
So
let's wisen up. And even if you get knocked out of the box and you get your house sold out from under you, do not give up. Do not give up. You have not just lost. The only time that you lose is when you give up.
Right.
Get back on that horse, study some more, and go back after them.
Yeah.
Because I'll guarantee you there's something that you could be doing that you're not doing. And you just need to do some research and some study to find out what your rights are to go enforce them. And your key is to study equity. Just enough of the at-law side to get in the at-law side so that you can get into the court and get in that door of equity, because equity is where you want to be.
Yeah.
Study equity. Study trust. The first dimension or the first division of equity is trust.
Yes.
The second one is fraud, mistake, breach of performance. That's the second division. And the more modern view is a third one. They break it down even further, but I'm not going to talk about that. Just keep it simple, the two. Trust on one division, mistake and fraud and performance on the other division. That's equity. Study equity. You only got about 10 or 15 maxims in equity that run the whole show in equity.
Yeah.
Go to Wikipedia and do a search for equitable maxims, and they'll pop right up.
Yeah.
Know them like the back of your hand.
Yeah.
Anything else?
No, that was great. Basically, the findings in fact and law is basically, okay, this, fine. Can you show me where the defects are or something like that, basically? And then amend the pleading. Request to amend the pleadings if you've made a mistake and go back in there.
Yes, amend your motion, amend your pleading, whatever it is. Motion to reconsider. Come back in with the right stuff.
Yeah. Okay. Well, thanks. Have a good evening.
Take it up on appeal. Appeal the sucker.
Yeah, of course. Yes.
Come in with a counterclaim, another collateral attack. Something.
Okay, yeah, actually I have a question about that. So when you write your counterclaims or your collateral attack, which is after the fact, right? It's coming back again. In the public side, still using the maxims, right, to get the switches.
Yes, right. The maxims are the switches.
Okay. Sounds good.
And substantiate all the things that you're going to put in there with, colorable claims at least, with colorable grounds.
Right.
Colorable NOIs with colorable SOIs.
Yes. Oh, also, the one maxim, equity would take jurisdiction to avoid a multiplicity of suits.
Right.
Now, that is basically when there's, from what I understood, was when they were in different counties, or other parties, more than one party has a suit. What if, let's say someone has several cases, could they consolidate all the different cases together in a counterclaim to get them all into one court? Would that qualify for equity as well?
Yes, because it wants to consolidate them all, and
even if there's, say, like
doesn't
some
want
civil,
suits.
Say like 2 or 3 civil cases and one like criminal case, all based off one issue. Would that still qualify for equity in the counterclaim? To equity would consolidate the suits.
Yeah, there may be some problem with a criminal because they say that equity doesn't involve criminality, but that can be handled.
Well, NTT can be used.
A criminal case is nothing more than a civil case with an additional criminal element. And you can bring it back into the civil side by getting rid of the criminal element. And that's very easy to do.
How do you do that?
You plead guilty to the facts, but not to the charge. Because the plea is the criminality side of the civil case, which makes it criminal. Once you eliminate the plea, there is no controversy. That case goes bye-bye. And now you just got the civil, which you can do a merger on and get rid of it.
A lot of times, like I would assume, if you're in a criminal case and you tell the judge, Judge, I'm prepared to plead guilty to the facts. Okay, well, we'll be sentencing you accordingly.
No. If you're found guilty upon the end of the court and then sentenced accordingly. If you plead before, the case goes away. Then there is no case to be sentenced on. Like that movie, the Red October, when Ramius in that submarine told the guy to steer right into the torpedo coming at him. That's what you do. You steer right into the charges, and you get rid of the charges. If you stop and think about it, why would I plead guilty on it? Because you don't understand, because it's when you're found guilty, then you are sentenced. I'm not found guilty yet by the court. I'm going to plead guilty to the charge, but not to the, or plead guilty to the facts, but not to the charge.
Right. Isn't pleading guilty essentially saying I'm willing to pay? I'm gilding. Is guilty coming from the word gilded?
Down the criminal side of the case, and now you can pay it the civil side with the merger of the titles.
Yeah.
Otherwise, if you merge the titles on a criminal case, you still got the criminal part that you haven't dealt with, and you're still going to go to jail.
Yeah. So if you write a counterclaim or a cross complaint, I think in California they call them cross complaints, and you use that maxim in that counter complaint saying equity must act to prevent a multiplicity of suits, do you list all 3 or 4 or 5 court cases all in there? Do you know what I mean?
Yeah, it'd be all the parties that are listed. You want them all on one.
Well, most of the time the party is the people of the state of. That's usually the parties. When it's any kind of, government action. If it's not a private party, it's usually the people of. So it's just, the corporate people of the state of Florida or whatever. It's always the same people.
All the parties, whoever the parties say they are.
So the district attorneys, perhaps.
Stick them all on there.
Yep. Makes sense. And then, so you write one counter complaint and you could cover 3 or 4 suits and turn it into the court, and that should cover all the suits.
If you incorporate them in there, right? Yes.
So that's actually what I was wondering. On the pleading, you list all the court cases. You would list all the multiple court cases on one pleading, on one public pleading, as a counterclaim.
Yeah, you form a new trust, incorporate all the other sub-trusts.
Yeah. Interesting. Maybe and a notice of removal or a notice of withdrawal.
They're all just, a case is nothing more than a trust account setup that you agreed to because you signed it. You put it in action. And you never expressed it to be a trust, and therefore it's debtor creditor, and they're coming at you with charges. You're the only one who had the real ability to pay out of the trust, but you're not claiming it as a trust. You don't have the office of trustee to make a payment from it.
So, well, we're the equity and we're the asset title, and they're bringing the legal debt title. And if we don't...
If you claim and prove trust, yes.
So, but the legal title is 9/10, so they have 9/10 control of...
Yeah, they have the actual control of the whole thing. But see, you're in a misconstruement. You're the trustee.
Yeah.
You got possession. Liability's all on you.
But they have legal title.
No, they have beneficial title under misconstruement. You have legal title.
No, I don't. They do. I'm just kidding.
Well, that's the way you want it. Yeah, you want to reverse it. And when you claim trust and send it back to them as a special deposit, now you have reversed it. Now you got the beneficial title. You've created the records that it's trust. Then do a withdrawal order.
So now this brings me to another question. If you're going to blend like several cases together, would you just make one UCC filing potentially and list all the cases in, or not list all the cases, but essentially consolidate all the cases through the one UCC filing?
Yeah.
The UCC one claiming all the cases.
Yeah.
And then, right?
Yes, you could do it that way.
And then maybe list a trustee from each of the cases. For example, one of the prosecutors from each of the cases as potential trustees. Maybe like if you had 3 cases, you'd list 3 trustees, each of the district DAs from each of the cases.
Yeah, you could do it that way.
Oh, that makes sense. And then, yeah, that way you're dealing with it all at once. Just get it all taken care of. It's all the same thing. So put it all, consolidate, merge and consolidate.
Yeah, you could. But you get one chance. And then if you don't do it right, then you messed all 3 of them up, though.
Well, yeah, that's the problem. You you got to really figure out how to do it properly. I think it really comes back to writing a really good counterclaim, a good counterclaim in the public, and then your private counterclaim or your private NOI is basically your indenture, isn't it?
The counterclaim on the private side, it would be the indenture, right?
Yeah.
But you can't make that indenture public.
No. You have to write a public counterclaim, a public pleading counterclaim, cross bill.
Yes.
And that's
reflect back into what the actual facts are.
What's that?
Reflect back in from that on the private side what the actual facts are.
Right. So in your public pleading, you're including stuff like your SOIs, attachments,
colorable SOIs.
Right. Your UCCs. But also, are you addressing any of the controversies? You must be, because you're answering essentially in your cross complaint. You're making an answer.
No, that's the answer to the complaint. Now, if you got a counterclaim, they got to answer you.
Right. Okay, got it. But in your cross complaint, do you address some of the controversies? Or you just keep it about the private? What?
If I've got a counterclaim, do not put any of their at-law complaint stuff in there.
Even in your public pleading?
Yeah, because you're mixing up their stuff with your stuff, and you're arguing their stuff in your stuff, and you just breach your own public trust.
Got it. So you basically say it
You open
basically
the door for them to come in and talk about everything that you're in your stuff, which should be nothing but equity, and then you commingle, bring in stuff, and open the door for them to come walking in with their at-law stuff and argue you on your counter-complaint.
So do it.
You just shot yourself in the foot and hung you if you do that. Hung yourself.
Okay, I got it. Just stick with the maxims. Stick with the maxims, and basically that there is no remedy at law. And
the problem is finding out that people don't know how to do. They want to still argue that claim. No, you do not want to argue their claim. You want to argue your claim.
Got it.
And your claim is solely equity. Nothing in there about at-law anything.
Got it.
Because if you do, that's the only thing you're going to talk about, and you just gave them reason to talk about their at-law stuff, and you just brought the at-law side back into your equity, and you waived your equity.
Oh, I get it. You made a huge mess of it.
Yes, you breached it, and you lost it by waiving it. You talked about their at-law stuff in your equitable claim.
Oh.
Apples with oranges, and you got fruit salad. You got reamed.
Oh, goodness. Okay, that's really simple. It's so simple.
Yeah, that's what I've been talking about all this time. It's easy, folks, but you want to talk about both sides. You can't. You got to talk about one side and one side only.
You know what it is? It seems like it's like an ego thing, because really the thing is they don't have firsthand knowledge, and they're making all these assumptions and presumptions. And I think our natural tendency is like, no, but they're wrong. You guys are...
Natural tendency of man is to prove himself right, to have the last word, to argue. That's the nature of man.
It's such a dumb
You want
crap.
to come in humble, and you do not want to argue. You do not want to have the last word, and you do not want to fight.
Right. You're just there for your claim. Here's my claim. Where's the payment?
Yeah, what do you guys say to my claim, which is equitable?
Yes.
Well, we got a debtor-creditor contract here. I object. That's in at-law. We're not here to talk about that.
Oh, man.
We're in equity here. Equity says you got to talk about equitable things. Where's that in that pleading there that I've got in the four corners of this pleading? Where is there anything in here about at-law that we're talking about, your counterclaim, your debtor-creditor contract? No, we're talking here about in equity. In my counter-complaint, on the four corners of this document, it says equity. What about my equitable breach of trust? We don't argue anything about what plaintiff brought in here on a claim. Nothing about the contract debtor-creditor crap stuff, unless you open the door and hang yourself. It's really easy, folks. Whatever I put in that counterclaim, that's the only thing we got to talk about at a hearing. And if they're going to come in and talk about anything on their claim, which is not my counterclaim, we can't talk about that. And I would be objecting up and down the gazoo.
Got it.
So I hope that fleshed that out a little better.
Definitely. It's really becoming more clear. You just pay attention to your stuff. Let them worry about their stuff, whatever assumptions, presumptions they've made. That's their problem.
Arguing their claim.
Right.
Don't talk about it. Come in with your counterclaim and make them prove up that fact, because that's the issue that's on the plate right now, and it has to be proven, and it has to be judged, and you have to get an order from that.
Right.
You have to get it adjudicated. That's first, before you can even talk about their claim stuff.
Got it.
You got the first chance to come in and hit them with a flurry of karate chops that just knocks them all to heck.
Yes. And then basically the motions. Your motion, your protective order, and your
equity can't answer anything.
Right.
In fact, attorney can't even show up.
Yep.
Attorney can't even show up in equity.
Well, unless you've made him the trustee.
Yeah, then you want to Means him in as a witness, not as an attorney.
Right. Where's the payment? You have all the duties and obligations. Where's the payment?
And then he can't be the attorney.
Right. Then he's a trustee. No more attorney for you.
So that means he can't ever show up that case as an attorney.
Oh, wow. It's amazing. Okay.
Yeah, come on, people, let's get harder here. This is not that easy. I mean, not that hard. It's not rocket science.
But it's a complete paradigm shift. It is 180 degrees. It's 360 degrees plus another 180 degrees the other way. You have to spin your whole self in a circle and then start really paying attention to what your claim is, and that's it.
Yeah, but everybody so far off. You know, they think that you got to answer the no. You got to put the objections in and you don't have to answer theirs.
Right. Yes.
If you don't object, start opening your mouth, start talking about the at-law side on your counterclaim. You just waived your counterclaim and commingled and breached your own trust and hung yourself. You lost. And then you're going to say, hey, this NTT stuff doesn't work. No, you do not operate in court. So press *6, *1, and get in the queue line. Everybody wants to ask any questions.
All right. Thank you, Christian.
Okay, thanks, Jeff. Donald Lee, you're unmuted.
Hi, Christian. How are you doing?
Oh, not too bad. How are you?
I'm doing okay. Thanks. I wanted to get your take on a hypothetical situation. Maybe put it in from your viewpoint. Say, for example, you were given full power of attorney or unlimited power of attorney over a whole bunch of properties, and you wanted to do the most seamless way of claiming, withdrawing, and redepositing. Would it be easier for you to have all these properties put into your name so you can do it from first-hand perspective? That's what I'm curious about.
Well, if I really wanted to play it that way, I might want to have them form a trust with me. I'm the trustee, and that way they transfer all property to me. I have all property, and I am the trustee, therefore I can defend trust property.
Okay. All right.
The power of attorney is that you're kind of like an agency relationship. An agent is always, answerable to the principal. But as a trustee's not answerable to anybody. He can do whatever he wants with the property, including breach the trust. But he's got an obligation to the beneficiary to do the indenture of the trust, and that's what he must do. So if he does anything contrary, then he's in trouble.
Okay.
So if I formed a trust and had them all transfer all the property to me, now as trustee, I got sole discretion to do what I want with it, and I can totally do it,
So, okay, now if I become the trustee for all of this, then they would be coming after me, or they surely couldn't still be coming after the principal, could they?
Well, they're trying to get the res, right?
Right.
Now, if I have control of the res, they're really not coming to get me, but they're coming to get the res. But I can defend the res now because it's a trust. Beautiful. I got the right to defend all the property that I've got under the trust, under my trusteeship.
Okay. That's beautiful. Thank you so much, Christian.
As long as I operate within the indenture, I have a protection against me personally.
Well, it's always good to have protection nowadays. Fantastic. Thanks so much, Christian. I appreciate it.
Okay.
Okay, bye-bye.
Well, you're unmuted. Doyle, you're unmuted.
Hello, how are you?
Hey, good. How are you doing?
Oh, I guess I'm doing okay. back to the conversation that we were having with Jeff there a few minutes ago. What about those of us who have already done perhaps a counterclaim and we've screwed it up? Can we go back and withdraw that counterclaim and then put it back under equity?
Yes, you can.
So
as long as
that
that's where the case has been like 30 days, usually they close down after 30 days. But anytime within 30 days, you can put in something and open it back up.
Are you saying 30 days if there's been a order of the court or something?
Yeah, an order of a court, usually at that time starts the clock at 30 days and they actually close the case down. And from that, then you can't put something back in and get it open up again.
What about just a regular case that's not been perhaps adjudicated or no order has come from the bench?
They just come in and amend it then.
So this
is a First Amendment. You got that as a right. You don't have to ask for leave of court or anything like that.
Mm-hmm.
You can do a First Amendment as a right.
Uh-huh. So I just come in and say I want to, this is a motion to amend a previous counterclaim?
Yes. Come in that says amended motion, amended counterclaim. It is.
And then we just bring in maxims of law?
With the counterclaims, yes. Yeah.
Okay. Well, that does sound a lot easier. You had a chance to take a look at one of our indentures. Could you give some pointers on what we might have done incorrectly?
How about we do that for something I get a chance to study it, because all I did was glance through it real quick.
Oh, okay.
But yeah, it was deficient. It's like what I was starting to say. We've got a twofold problem. We've got okay, the trust and be able to create the evidence, prove the trust, and then once we've got the records of the proof, then we got another problem. We got this second problem. We got this court problem because we don't know how to operate in court.
Right, and mixing venues seems to be the biggest problem.
Yeah. In your particular case, from what I could gather on there, you made a real fundamental form mistake, and that was you put in this as a memorandum in support, but there was no motion that was supporting.
Uh-huh.
And that was a mistake, because the motion is what orders the court to do something, and if there was no motion in the court ordering the court to do something, then there's nothing for the court to do.
Right. So they have to have an order before they can do something.
Well, a motion.
Yeah.
Well, I think you kind of based it off of what I had done. I gave somebody right out of O'Connor's Federal Rules of Civil Trials. I gave them two documents. One of the two documents was on a temporary restraining order, was the order for a TRO and the memorandum in support of.
Right.
I didn't give them the motion because the motion that's in another section. That's under motions. And I figured that that party should know how to put a motion together. So apparently this has been floating around, and maybe you got that as a guide, but then the memorandum in support of, what's it supporting? It's supporting a motion for a temporary restraining order.
Right. Well, we actually have the book, O'Connor's book on forms and what have you, and that's what we were using as our guide on that.
Uh-huh. But you've got to go to the motion section to pull up a motion.
Right. Yeah.
And then the TRO is the order, and then it's the memorandum, which goes with the motion. So there's three documents.
So it's not too late to correct that flaw, is it?
No, it's not. No. Now the second thing was you've asked for a temporary restraining order on something that's already been done, so how could you restrain something that's already been done?
Yeah. Well, the temporary restraining order went in before the act was completed. However, I think the flaw was not going and asking for the temporary restraining order from the judge. So that was a flaw.
Yeah, what you really wanted was a mandatory injunction, but the mandatory injunction is only when you win.
Uh-huh.
But you would want maybe a preliminary injunction to say, or a temporary restraining order to just freeze everything from happening. Now, that would be if they came at you. But if you came at them, then there would be no need for that.
Mm-hmm. Okay.
I still could ask for, if I came at them, I could still ask for a preliminary injunction to freeze all of plaintiff's actions against me.
Uh-huh.
And make it so they can't destroy information.
Mm-hmm.
And then the case would have to be heard, and then if I won the case, then I would put in there, I would also have it in there for the mandatory injunction, and then when I won the case, I would get the mandatory injunction order, and that would be ordering them to do what the trust required them to do.
Uh-huh. Okay.
Now, that's nothing. Now, the other thing I could see was, I think you need to beef up your counterclaim as to some of the things on there was you had the intent and purpose and the parties and things in there. But now that might be too much information, too much private information on that.
Oh.
And you might want to have come in with a cause of action, which was more of a boilerplate thing that they would recognize, and that cause of action would be, say, a payment was made, or another one, maybe breach of trust.
Mm-hmm. And then come in with the maxims?
Yes. Mm-hmm.
What about whenever, we last Saturday we talked about, I think Chris talked about the doing a withdrawal of a case. Should that be done verbally in the hearing, or can one put a motion in and put the orders to withdraw, redeposit, and terminate?
Yeah, because, we're working on that right now. So, but, yeah, it's a withdrawal order. Now, that party just put in a withdrawal order, and that was it. But we would come in with the resolved, and resolved being that the trust was expressed. Then it would be the acknowledgement of the debt to stop the running of the prescription, the withdrawal order, and a redeposit order, and then with the instructions to extinguish the debt and obligations and discharge.
So
now you could stop it there. I would go even farther. I would go to the proceeds therefrom, and I would trace them. And I would do a stay and freeze the trustee's assets. And then I could have the court appoint a receiver to trace and seize the proceeds.
Uh-huh. So
now all that documentation and stuff doesn't exist yet, and it all has to be written up. But that's the game plan.
Uh-huh.
Instead of stopping at just a withdrawal order, which seemed to have worked, for 3 or 4 cases. But I would go with the one step farther, at least to the point to where I'm going to start going after the proceeds. I might want to stop there. But if it was me, I would go farther. So.
Uh-huh. Now, would these be all individual orders, or could you do one motion with all the orders in it?
I could do one.
Send that in?
Yep, could just do one.
Okay. All right. Well, I appreciate your help.
Yeah, the wheels of progress turn slowly, and We could sure use the help.
Oh, good. Good.
So if anybody out there wants help in any way, especially maybe transcribing any recordings that we got,
yeah.
contact Faith to Trust. She would gladly use your help.
Exactly. Many of us are in Marshall's position. We got arrows coming at us from every direction. They got to send them off.
Okay. Anything else?
I think that's all I have for this evening. Thank you.
Okay. Guess we got a clear board again. Anybody has a question, press *6, *1 to get in the queue line. Chris, you're unmuted. Chris, you're unmuted.
Oh, I'm sorry. I had my mute button on. Sorry. In regards to the withdrawal order, can we work over that just a little bit? Or would you rather have it on the teacher's call?
Well, we might talk about it basically, but if we get too far involved, I might want to shelve it. So.
Yeah, not a problem. Okay, so the withdrawal order goes in, and the basic information would be to resolve the trust. In other words, if you were to send in a merger of some form or fashion of where that is considered a payment, then that would be one of the elements. Is that correct?
Yeah, I would do like we were talking about the DEP wart.
Yeah, right. Okay.
So that would be DEP/-WORT.
Yeah.
Where WORT, the word is withdrawal, order, redeposit, and termination, and trace.
The tracer, for some reason, that has eluded me. Can you go through what that means? Is that to go to the clerk, or is there instructions that you can promote tonight?
Well, as we were talking about, I think it was that section in under the trust in book 90 of CJS where it was talking about, I think it was 453, where it was talking about the appointment of a receiver.
Okay.
Well, a receiver, that's got to be maybe possibly involuntary bankruptcy. So that's like a freeze or a stay on their assets of the trustee, and a receiver appointed over them to probably trace and seize the proceeds.
Okay, and does that go back to what we were talking about, the knee exit, or however you say that?
Knee exit, yeah, that possibly could be used, but that might not be necessary if you're going to do it through the court, because that's kind of like what you're doing anyway.
Okay, that retired judge down there in Florida, I received some papers inadvertently that it appears, and I haven't had a chance to talk to Eric about this, we're going to work on this one project, that it's very, very, I mean, it's so similar to the knee exit. Is that how you say that?
Yes, knee
exit. The forms are almost identical. And it's on the debtor creditor side, but I think that we've got a winner. You know, I think that we can put this package together this week.
Yeah, but see, I would go to equity and ask equity, this is what I want you to do, which is equitable.
Okay.
And it would be equitable to appoint a receiver, freeze the assets of the trustee, and trace the proceeds.
Would it help in some people's cases? Would it help for people to have a forensic audit on, say, for instance, the mortgages? That would support the fact that it would give them a jump start on doing a tracer to go locate all the assets?
Okay, what about the assets?
Well, say for instance, while you're working on the debtor-creditor side, you have a forensic audit done on the deed of trust. Therefore, some of the facts that they come up with would be the blocks that the promissory note had been converted into a security instrument. Therefore, it was sold as a block. Therefore, it's part of a QSIP, which is on the open market. Would any of that be supportive evidence to doing a tracer?
Yeah, but I might have to use a public side trust to, say, enforce it statutorily wise and take advantage of that forensic audit evidence.
So would that be kind of like a public dummy trust account just to hold and harbor evidence?
Yeah, because I might have to shield the knowledge of the private trust. I may have to have a public trust, a colorable public trust on the public side.
And would this be kind of like a protective order, but it would work similar in nature to a public trust? Would that be kind of like what you're thinking here?
Kind of, because if we're saying we've got a public agency that's doing a forensic accounting that can't be crossed back into my private, because if I did that, it would be breaching my own trust. So how am I going to do that? That's the trick.
Yeah.
But to act as an interface, I might come up with another statutory colorable trust that since they're so identical, they're like identity of interest. There's two parties, but they look so close that they're treated as one. So I got a private trust and a public trust that are so similar they look alike.
Yeah, that's part of the problem here. So do you think a protective order on the public side would, you think that there could be some kind of maybe there's a protective...
That's why I like coming just solely into equity, have equity grant me through, kind of looks like they're granting me, but I'm ordering through equity. If they can't give me a relief for what I want, then they need to go on the at-law side and grant me the at-law remedy. Now, the court of equity could put the trustee's receiver into a resulting trust by operation of law until this is froze the assets, put all these assets into a resulting trust, and then the receiver appointed by the court would be the trustee over the all the assets of the resulting trust, which was the trustee's assets, the other trustee's assets. But I did all this through equity instead of coming at law.
In regards to a court of equity, now that the U.S. District Courts, when you file a complaint or a countersuit in regards to a mortgage foreclosure and or a unlawful detainer, one of the things that they offer is an Article III court along with signing off to have a jury trial. Do you feel that that is probably the avenue that people would want to choose when they go to U.S. District Court? And would that elicit or invoke the equity side of court through the Article III judge?
I'm not quite following you. Kind of go through that again.
Okay. The last set of papers that I took down to the U.S. District Court, the clerk said that we're now offering Article III judges to hear cases.
Where do you think there are judges at?
Huh?
Colorable Article III judges?
Well, nevertheless, I mean, it's an offering that you can't really refuse because equity and common law is so closely similar.
It's like they're saying they're Article III judges, but they're not Article III judges. But although they are from an Article III labeled court, and they're judges from that court. But are they true Article 3 judges? No.
Well, so how do you elicit
equivalent? Okay, so they're offering you these Article 3 judges for what now? Continue on. Still there, Chris? I dropped off. You come back on?
Yeah, I must have got bumped off.
Yeah.
Okay, the question I'm asking, and I think this is very, very important for everybody, in order to get a authorized, authentic court of equity, do you have any ideas that we can go about making sure that we're not going to be compromised by the statutory equity court and or Article 3 court? Do you have an exact consideration of how we can get right down to the meat of the matter here and bypass all the statutory considerations that a court might want to bring in?
It's really simple. Don't argue the at-law stuff. You want a court of equity, don't argue the at-law stuff. That simple.
So are you saying that all judges are qualified to hear equity on the non-statutory side?
Yes. Equity is equity. Runs by the maxims. It's invoking the court of equity and not breaching your equity that you're setting up by the at-law stuff and bringing it in and arguing it.
Okay. Would you feel that a person should at least give an attempt to the financial institution to merge the titles voluntarily before you actually show up in a courtroom? I mean, should you not go ahead and at least attempt to try to square this up between you and the institution, the financial institution, before you walk into a court? Therefore, you have unclean hands, you have breach of trust, trustees fail to do their job. Which angle are you favoring at this point?
I think we should go through the equitable side and let the discretion of the court. If they can't give us relief, then they should give us some of the other stuff that we might suggest to them.
Like what kind of
the antitrust and all that other stuff.
Oh, the antitrust. Okay. All right. So would that be kind of a proposition or a like an offer that they can't refuse? I mean, if they're not going to give you the opportunity to settle this stuff in trust and equity, therefore you are requiring them or mandating them to go back and revisit the statutory TILA, RESPA, antitrust, and blah, blah, blah?
Yeah, because while I'm in the court of equity, if they're not going to do the duty of the trust, and let's say they can't, they refuse. While we're in equity, I could get the court to decree that you're in breach of antitrust. And I could bypass all the court stuff that I got to do on the at-law side to get a judgment for antitrust. I don't have to do all that.
I'm sorry.
I go direct to an order to order the judge, get a judge's order that they're deemed guilty on antitrust.
What about that, the statutes at large at 48 at 112 that actually says...
Any of that stuff could be a remedy, but the remedy, if you went on the at-law side, you've got to go through all the rigmarole, the court drama, and the court pleadings, and all the other battles. No. Yeah. If you go to equity first, you can eliminate all that stuff in between and go directly to an order of a win on anything that you ask for at law, if you can't get the relief on the equity side.
Okay. Now, what, in regards to the objections, I find that as being a very favorable thing for inadequate people that show up in a courtroom that don't know how to handle themselves. But what about using, I made a mistake, this was not meant to be construed as being reverted back into statutory law. This is only to remain on the private. Therefore, I made a mistake. You think that that's an argumental or a tool that we can use in our approach to the courts if we made a mistake? And
possibly, because, you know, when the judge comes in, he tries to take jurisdiction, he walks off the bench, goes outside, comes back in, and he restarts the whole thing again. And you never knew, you thought it was the same case. Do the same thing.
Okay. In other words,
maybe another motion put in to correct what you did under a mistake might suffice.
Uh-huh. Because, I mean, there's a lot of people out here on the streets that are faced with having to go into the courtroom, and yes, you're right. This is not their venue. This is not what they're used to. They're not being paid to do this. Therefore, they don't go to court to find out the ropes of
But you know what Esty says? He who sleeps on his rights has no rights. If you don't defend your rights by going into court, you've got no rights.
But the argument is how much time does anybody have to go to court to learn the ropes?
That's the learning curve of being sovereign and sui juris.
Yeah.
The king knows how to do everything in his realm. Do you? Then I guess you must not be king. You're a king wannabe. Go back to school, and then when you graduate, maybe you can apply for the kingship exam again.
Even kings make mistakes.
Yes, they do. But they know how to correct them.
That's right. And it's like practicing swordsmanship. If you have no opponent to practice with, how are you going to know how to defend yourself?
Well, let's put it this way. These kings from little on are trained to be kings, but you were never trained to be king, I'm sorry to say. But there's information out there. You can self-train yourself. And if we stick together as a group and we share information back and forth and we try to help one another, and, you know, that's the only strength we've got. And we need to stop arguing amongst ourselves.
That's true. And I do believe that the equity is more fair, mostly because, like I said, you know, I've got some correspondence back on some of these letters that I sent out, and I can't wait to open these things up. But it appears to me that I've got their undivided attention, and that means that they're not expecting people to claim trust, and they're not expecting to go on equity. Therefore, it no longer is under the presumption that you're a statutory debtor and that you're a trustee that needs to make a payment. It's flipped it all around, and I'm pretty sure, if I'm not mistaken, I'm pretty sure that they are not expecting this kind of activity. And if it becomes a wave, of which I believe it's going to be within the next 6 to 12 months, it's going to be a wave of people claiming trust. These people that have worked themselves into statutory laws that they've lobbied in their favor for all these years are going to be taken by surprise by the trust and equity of which it truly was. You know, especially since you were basing the fact that a trust doesn't have to be claimed, it doesn't have to be public, but when a person like a grantor that signs their signature comes forward and claims that, all of a sudden it brings it into focus that, oh, this is a trust. Oh, the banks have been calling themselves trustee. Oh, well, they have failed to take the proceeds and the fractionalizations and all the interest and whatnot that are on the open market and apply it against the debt. Therefore, they are in breach of trust. So I think that the times are passing of where we've got some clarity. We've got some of the documents out there, and these test runs that we're doing are going to start showing some results of where sooner or later most of these banks are going to realize that there is no defense. They no longer can rest on their own laurels with their own statutory laws that they lobbied Congress to put in place for their favoritism, that they're going to fail. They're going to fail a lot of people as soon as people start getting educated and whatnot.
Yeah, your power, your win is in equity.
Yeah.
And
because
equity is only run by 10 to 15 maxims versus 63 million plus statutes and codes.
That's right. Now I've got another question that you just triggered in me. Equity basically is living parties that are sentient beings. In these particular matters, only injured parties can come, or people that are considered the parties that are in debt. No attorneys and no bankers and no CEOs can actually show up in a court of equity. Is that correct?
Yep, only real men and women. With rights.
So in other words, you can actually elicit and invoke a equity court, and if it's true to its own, the court is true to its own, that means that no fictitious representative, authorized agent, and or attorneys can be allowed into that courtroom. Is that correct?
Yes, and not only that, it's also the fictitious laws, public policy, statutes and codes since 1933. All of that can't be brought into a court of equity either.
A true court of equity.
Yes, right.
So you have to stick to your guns when you walk into a court and you invoke equity. You're going to have to be the one that enforces the fact that they're not to misconstrue, they're not to commingle, they're not to go back into statutory law. And that means that people are going to have some pretty big kahunas, right, in order to do that kind of activity?
And that kind of kahunas comes by understanding the basics of what equity is and the difference between that and public policy, the at-law side, and all that other stuff, which does not apply. And being consistent to recognize that all this stuff is not that hard.
Yeah.
You can't bring in the at-law side, and you just have to recognize what is the at-law side. Well, it's everything that's not got to do with the 10 or 12 maxims. That's easy, folks.
Yeah. Well, I think it comes down to the age of majority. And God bless you, Christian, you have taught me things that I have never, ever heard, ever, before we started these calls and whatnot. And the age of majority is one of those that when you become coherent, you start really understanding what trust and equity is all about, you actually start becoming the age of majority of where it's a growing process. It doesn't happen overnight. I mean, some people, yes, they've been in court and this and that, they can probably handle themselves, but for a lot of folks out there that have always been a ward of the court, it's going to be a little more time involved and a little more education for them to actually to get that place where they can actually claim themselves as an age of majority.
Yeah, we're all wards of the court, but we're actually, everybody needs to know the definition of power. Power is the ability to recognize that you have two choices to make. And when you've got that power, that's really the age of majority, because now you can make the choice for the trust instead of, which is the special deposit, instead of the general, which was the debtor-creditor realm. It's the choice between the relationship that you want, either special relationship being trust or general relation being debtor-creditor. It's the choice of the relation. That is the power, and that is the age of majority.
Yeah.
Don't confuse power with force. Force is physical means to force somebody in coercion. We all have the power, which is the choice to make the choice between the relation between general and special relation. And that's the age of majority.
Going back to the statutes at large at 48, the obligations and duties of government based off of the Bankruptcy Act, how are you feeling these days in regards to their duties and obligations in making sure that these things actually do come to a full completion upon approach? In other words, if I was an individual that, yes, I've determined that, HCR 192 and stat at 48 shows that upon my approach that if I give them any type of communications that they are to handle these matters, how are you feeling about that angle
Well, if you come at them under that statutory public trust, there's a chance that we're probably not going to succeed because it is a public trust. Public runs the whole thing, and we're not in equity when we do that. So again, the key lies to come into equity, and if I can't get a relief out of equity, equity will grant me the remedy then on the at-law side. But I can't go directly into the at-law side and get a remedy because there is no adequate remedy at law.
That's what you were trying to tell me the other night, is that your first attempt should not be through statutes. It should be in equity. Therefore, if there's no result, I understand now that what you were trying. I wanted to ask you personally about that, but now you just answered it. Is that your first attempt should be in equity, and if the law fails, then you have only one other recourse, and that's to fall back onto the statutory type of remedies. Is that correct?
Yes. The law doesn't fail. Equity fails because it can't give you my relief for whatever reason. And then it must give me a remedy at the at-law side.
But wouldn't that be kind of defrauding trust, or wouldn't that be a breach of trust on the government's behalf, or dishonor on their behalf? And what would you do if you caught them basically compromising equity and trust in that manner? What would you do?
You should find them guilty in an antitrust and give me the order and the relief for the breach of the antitrust. Without all the court drama and the sweat that took me to get it there, because that was all bypassed. And then if I went through court, I could have probably lost at law. But if I go through equity, equity is going to grant me that at-law remedy if I can't get a relief. Without all the hassle, without all the work.
Could this be in any capacity an issue that if the treasonable acts or the defrauding or dishonor to trust and equity upon any government, I'm not just talking about America, but any government, is that an issue for Commerce and for the UPU?
No.
It wouldn't be?
No, because the UPU is nothing more than admiralty, statutory, merchant law, which is public again. And I can't, that's the at-law side. I can't get a remedy in there.
Yeah, but I think that what I'm trying to say here is that if there is mass Armageddon or genocide with mortgages and foreclosures, that the country and the commerce is going to hell and the whole world is being affected by it, you don't think that the UPU wouldn't have a word to say about that?
All one world order. It's all one world order. It's controlled by the few.
All right. Well, it was worth
a shot. Court of equity is in the conscience of everybody. Equity comes back to God's consciousness of everybody, that the laws were written on your heart.
Yes, I do agree, and I do acknowledge what you're saying. Is there a world international court that can address issues under equity and trust?
I would imagine so, because equity exists in any chancery. That might be the way to better go that way, if you wanted a higher realm instead of, say, the UPU.
Yeah. Well, I'm trying to brainstorm this, and I don't mind sharing my brainstorming with people on the call, because I'm trying to induce other people to think for themselves. And if anybody out there has anything that they come up with, please post any of your thinking at one of our several sites for us to review, because it's that important for people to come forward with their ideas. But Christian, I think I'm finished right now. But it's been good. I think I got some of the answers of putting the rest of that notice of withdrawal order together. I do appreciate you spending some time with me on that.
Okay. Did you hear back from those people on any information?
Which ones?
The withdrawal orders.
Oh, actually, to tell the truth, we had a traffic ticket. We actually we did that, and we also put the judge on the spot of which the gal had walked into court, and this is one of the most ruthless judges that we've got here in the county, and I had said that, you know, in that correspondence that this is a private matter. I don't wish to have this on the public side. Therefore, I'm asking in chambers hearing on this issue. And by the way, I just want to let you know that I know you guys took my signature and that you had placed securities in regards to this case. And I want those assets brought forward. And I want you to be able to, in chambers, execute the closure of this case. Well, she showed up. She showed up in front of the judge, and this guy is just a, you know, he's an old chapped guy. He absolutely has nothing but just the money and the cash register going through his court, and she says that he held his head down to the table, and she says, well, did you read my correspondence that I had sent to you this last week? And he says, yes, but we're not going to address that right now. And as he's holding his head down, and he says, this case is being continued 2 months from now. So she calls me up, and she says, you won't believe what happened. That's the first time she's ever seen this judge actually act in some kind of a capacity, being caught with his pants down. And I says, yes, we got him. So I've got to do something in regards to the withdrawal order to take it out of just regular statutory. And this is going to be kind of a test baby. It's going to be one of those that I'm just going to start testing this thing and see how it works out with small cases. Traffic tickets is a good way of dealing with it, but what came about a couple of weeks ago is we withdrew a case on an unlawful detainer, and we reestablished that as a counter complaint in U.S. District Court, and it wasn't necessary to file a counter complaint. And what I realized is that the county would have been the county and the state would have been in complete cooperation with just a notice of withdrawal. And that's when all this stuff dawned on me. It's just like, geez, Chris, why in the hell do you want to continue this thing? You know, these cases can be stopped right here, right now by withdrawing.
Yeah, and then going the other farther, acknowledge the debtor obligation. To the extinguishment
that's the consideration we have to work through. And like I says to anybody that's on the call that's listening to this stuff is that we're trying to brainstorm this stuff. But I do believe that when
you withdrew the case, but you didn't terminate the case.
Yes, I did. 3 weeks before that, I had sent trust merger papers to the county auditor, to the county clerk on the unlawful detainer.
Did you give orders to terminate the case?
Yes.
Oh, okay.
Yes. And I haven't heard word, so I'm going to have to prepare papers this week in regards to that. And I was kind of looking forward to having you. Yes. It was all done. The only thing is that the notice of dishonor happened. But I wanted to have a chance to talk to you privately, you know, on one of the teachers' calls about this particular matter. But I think that once we knock out a couple formulas and templates here, I think we're good to go. It doesn't have to be a big, you know, it doesn't have to be a big dragged out document. It's a one-page document. That's all.
Yeah. A couple other pages maybe with some that all plug in as modules. Yeah.
Yeah, but I think that the trust merger papers are. They've had them and they have not responded. I'm sure that they're shrieking because I have the ability to go on the debtor creditor and file a complaint against them for dishonor with the IRS, and that means that they're going to be up for review. And I'm sure that they are going to be a little more cooperative because I've given them debtor creditor notifications of W-8s and BENs and IMYs and their federal ID number, and that they are a corporation doing business on Dun & Bradstreet, and that they've got offshore accounts. I've given them all that communication. They, you know, over the last few years, they know who I am.
Mm-hmm.
And that means that by breaching the trust of finishing these things off under trust merger, what I'm trying to do is, and I'm not trying to shut them down, what I'm trying to do is massage them to get their cooperation. That's what I'm trying to do. And just see where it goes. So,
we'll see how it turns out.
Yeah, that's the best we can do at this point, is test the waters and see where it goes. But I've certainly have cranked out enough information that they know that they need to be somewhat gentle dealing with me, because it could be a big fiasco for them. And like what we've talked about, I'm not looking forward to destroying their asset base or divulging their secret trades of how much they're taking out of the American people. I'm not interested in all that. What I'm interested in is
defend themselves in equity.
Say it again.
Really, they win in equity, and there's where your win is, in equity. But then we're the only ones who can flub it up. We're the only ones who can lose it.
Yep. And I think in some respects, I don't know if I'm even actually qualified to claim myself as an Asian majority, even though I've been working side by side with you and the other teachers and whatnot. I actually sit there and periodically I go through the jitters. It's like, what do you do? What do you do? Like the other night, you asked me a question. I'm sitting there saying, oh, you know, it's like, come on, Chris. You know, he challenged you to be on point with what it is you know. And it made a big impact to sit there and say to myself, well, you're on these calls. I've clocked in over 3,000 hours by now. I mean, what's 10 months do for you, you know? But the thing is that maybe what we need is we need a special call where we challenge each other. What's the answer to this? And then somebody else has to respond. You put them on a spot. I don't know what the right answer is, but we need to be sharp as a whip, because when it comes time and you're standing in front of a judge or a bunch of these 7-digit attorneys, you're going to have to be sharp as a whip to come up with these answers.
I challenge those people that are on the calls if whether or not they have gone and gotten a hold of the Corpus Juris Secundum Book 30 and read that 250 pages of equity for themselves. Because that is our remedy or relief. Then we need to know equity like the back of our hand.
That's right. But I certainly believe that that everything you've been teaching is right on course. It goes right to the primary point of all laws, and trust and equity is definitely where it's at, and it's just a matter of mastering enough understanding to be able to walk the talk and to actually engage every day with every person with the matter of being a king and looking at different choices. We're a society that reacts. We're not a society, generally we're not a society that responds in a manner of choosing from it. I know that I have a hard time slowing myself down to where I can actually take choices, and over the years I've actually gotten a little better. I'm no longer just reacting like a jack of all trades. I actually will look at something and I actually see the effectiveness and the win rate, the success rate of my whole being. Everything about me is changing because I stand back and just don't react to just anything haphazardly without stopping and thinking about what the ramifications or, you know, what's going to transpire from whatever comes out of my body or my mind or my soul or heart, whatever. And so, especially this last 10 months, it's really made me stop and think. And my whole life has changed because of you and about trust and equity. I'm actually owning more of my kingship like I've never owned in my life ever before. So this is what I've been waiting for pretty much most of my life, is to get to this stage of where I can actually say that, yes, I'm actually owning this stuff, and it feels good. You know, it really does.
Mm-hmm.
So
well, there's a difference between walking the path, knowing the path, and walking the path. And then you also have to, before you walk the path, you got to know the path. So.
Mhm.
I
just wish I could do
more.
Before
that,
I'm sorry.
If you do the jump before that, you'll end up falling.
Yeah, and I'm used to going crash and boom boom. I try to do too much, and then I get overwhelmed, and then I go crash and boom boom. So I just wish I could do more for other people, but there's a sense right now to do preservation and to kind of stay with what is necessary in my life to take care of. And when I'm back up and running, I can start helping other people in a much more grand way. But right now, I'm kind of like in that incubation of where I need to study, I need to research, I need to get this stuff down. Oh, by the way, I want to let you know that we've got a brewing group of people here in California that that have a very strong interest in creating some kind of education among ourselves, and there's several people that want to come in as TAs. I probably have 6 people right now, CW, here in California that have a strong interest in getting educated and whatnot. So maybe at some point, one of the TA calls, we can talk about that too. Maybe we can get a little more support from the other TAs with some of these people out here in California.
Mm-hmm. Okay.
So, yeah, we're growing. There's no doubt in my mind that we're definitely on the move and we're growing. And I think that this stuff is coming faster than any of us really knows. It's coming right down the pike. Anyway, I'll let you go, and thank you, and I'll let you get back to the next caller, and I'll talk to you on Monday, I guess, huh?
Okay. Thank you, Chris.
Bye-bye.
Okay, next caller, you're unmuted.
Hi, Kristen. This is Donna Lee again, Florida.
Hi. Yeah.
Hey. I've heard you hours and hours and hours of calls, and I've done a lot of looking up of definitions and everything. And the more definitions I look up, and the more I listen to you, the more exciting it gets. I think that the more people look up these definitions. I mean, this is like the NTT is incredible stuff. It's absolutely incredible. But I've really been having a paradigm shift, and, as far as, hypothetically speaking, not that anybody ever did not like the IRS or anything, a lot of people never considered them as being an ally in any way, shape, or form, but, we had a paradigm shift in that respect, which is good. And I was looking over mortgages and deeds of trust today, and I noticed first off, I noticed how absolutely similar they are. I mean, line for line, word for word, it's absolutely incredible. But the major differences that I saw between a mortgage and a deed of trust is a mortgage calls the borrower a mortgagor, and on a deed of trust, they call the borrower the trustor. And in the definitions, which starts on the first page and goes through page 2 on the mortgage, the definitions go from A through P. On a deed of trust, the definitions go from A, starting with security instrument, to Q. The only difference in the major difference I can see between the definitions in the mortgage, A through P, is compared to the deed of trust, which the definitions go from A through Q, is on the deed of trust, it has a trustee. It names a trustee. Okay, and also I was looking through a promissory note, and that's showing an anonymous bank as a beneficiary. And I've heard you say several times before that is a hypothetical trust receipt. Okay? So, I mean, wouldn't these also, these, one of these is recorded, the deed of trust and the mortgages are recorded, and that has trust language in it, but then the promissory notes aren't, but there's trust language in both. I mean, that seems like a pretty...
yeah, one's trust, the other one's not.
Right. I mean, that seems like pretty much solid indication, worst case scenario of a trust, wouldn't it?
Yeah, because they're expressing the trustee to be a trust.
Right.
The security agreement is probably it's not being expressed, but it is a trust. Well, anyway.
Right. Okay.
So those two represents your debt titles, and the promissory note represents the equitable asset title.
Mm-hmm.
But the reason why they never record the promissory note into the public would be now they've merged both the note and the equitable note and the debt titles, merged it in the public, and they would terminate everything. They would extinguish the debt. So they never do that.
Interesting. What I was thinking was, if a situation ever came along hypothetically where a judge could say, I don't see a trust here.
That's what you want him to say.
Okay.
Now he opened the door for you to ask for an in-camera hearing so you could prove the trust.
Right. And I know to do the NOIs and the SOIs and everything, but on top of that, just pushing a deed of trust or a mortgage in front of them, along with a copy. How could they not see a trust in chambers?
Well, deed of trust, that one is a trust, so they'd have to, but that would be a public trust.
Mm-hmm.
So you'd have to prove all the elements of the trust. But if you did prove all the elements, then you've got a trust that the law must see.
Okay. Well, I'm pretty happy I'm in a judicial state.
Well, even if you were in a non-judicial state, the first thing you should do is switch it from non-judicial to get a court action and make it judicial. That's where everybody makes their first mistake. Don't let them proceed without a judicial action. Bring an action against them. Now, that action against them is going to stop all the proceedings because you're going to walk in there with an enjoining action, a temporary restraining order, a preliminary injunction, freeze all the stuff until your case can be heard.
Mm-hmm. Oh, I wanted to ask you, have you heard about they're trying to change Florida into a deed in trust state? Have you heard that?
Yeah, I've heard about that, yeah.
Okay. That's pretty wild. I don't even know what that's supposed to mean. An act in trust. A deed is an act.
Well, they're going to change it from a security agreement to where you're going to be required to have a deed of trust. And then they wouldn't have to go through the courts to have any of the judicial enforcements. They'll just go directly to any, like what they're doing in the non-judicial states. They're trying to turn it into a judicial state.
I was wondering, what is there any difference between a deed of trust and a deed in trust?
Well, now the trust is already set up, and the trustee can liquidate the property right off bat without going through the courts.
Amazing. That's just incredible. Okay. Well, again, I really appreciate your time and effort and everything you do, Kristen. You and Lisa are absolutely amazing, and I can't thank you enough. You've been great, great friends, and I really appreciate it and everything that you both do. And have a fantastic evening.
Thank you. We appreciate it. Dan, you're unmuted. Dan, you're unmuted.
Can you hear me now?
Yeah, go ahead. We can hear you now.
Okay. I wanted to piggyback on what Donna was just saying. You said that the deed of trust is a public trust. Now, in that trust, we are labeled as the trustor or the grantor or whatever. We're labeled as the creators.
No. The previous owner was the grantor, and we were listed as the trustees.
Well, I've got in my paperwork it actually says that the previous owner was a grantor, and that I'm the I can't remember. It's not co-grantor. It's another word for grantor. But then in my actual deed of trust, I am labeled as the trustor. Because I've been looking over it today, asking Donna different questions and stuff like that. But
okay, maybe it's different in your state, but the ones I've seen, successor, the person who was selling the property was grantor, and then the buyer was trustee.
Yeah, I know what you're talking about. Right here on my deed of trust, and this is Alaska, so, clear across the continent from where you're at. Right here it says, borrower is the trustor under this security instrument. So, right there under the security instrument, it's labeling us as the trustor. Now, this is a public trust, correct?
Yeah, if it was filed into the county, yeah.
Yes, it was. Okay. So let's go ahead and claim this as being ours, and then let's come in with new instructions, not a complete new. Let's see. How do I want to go with this? Not right. Yeah, there you go. A new indenture. Like what I'm. Yeah. They have misconstrued this for me since I sat down at the negotiation table, and I just completely screwed up, and I didn't do my job as the trustor. They did it for me because I already had this. I already had this
about all along with NTT.
Right, exactly. So if I just come back through and I correct the mistake, yeah. Okay, yeah, you're completing my thoughts before I even say them. Damn it, Christian, knock it off. Now, another question I had for you, Christian, is the very last paragraph before we sign, and I quote, it says, by signing below, borrower accepts and agrees to the terms and covenants contained in this security instrument, and in any rider executed by the borrower and recorded with it. Mm-hmm. Why can't we just go in and create our own new rider and correct all the mistakes and all the misconstruements and be done with it?
There you go. Give it a whirl.
Fantastic. I've already got one laid out. I'll try it. I'll be your guinea pig. I'm your Huckleberry.
The withdrawal order and the extinguishment of the debt.
There you go. I like it. All right.
Do a dep ward.
A what?
A dep ward.
Dep ward. What is that?
DEP-wart. The D is debt, E is extinguishment, P is package. Wart is withdrawal, O is order, R is redeposit, and T is termination and trace. We got a DEP 1 package, a DEP 2 package we're going to release, and a DEP wart package.
All right, you're talking about stuff that I have never heard about before, so I'm going to have to
These are documents that we've been working on and putting into beta testing, and we're going to release them.
Okay. Well, I'm ready. I'm 2 months behind. I've been buying time with my mortgage or with Wells Fargo in the debtor creditor side, trying to get my trust going.
Well, we spent 10 months developing doctrine and documentation, and through that 10 months, we've come up with these 3 packages.
Fantastic. If you need a guinea pig, I'm primed and ready to go. I'm sure you probably already got a couple other people out there that are in the same position I am, but
yeah.
I just got a letter yesterday from Wells Fargo stating that they cannot, this is funny, they cannot foreclose on me without getting a court order since I'm in the military. Well, I sent them a letter back asking them what contract they're going to show between me and them that's going to give the court permission to give them permission to foreclose on me, because I have no contract with Wells Fargo. They're not mentioned anywhere in the deed of trust or anything else. So, but that's just buying me time on the debtor creditor side. I need to quit playing in that realm and get over here to trusts, and that's what that's why I'm asking you these specific questions.
Well, that security agreement or the deed of trust recorded in the public, that public is an entity.
Right.
And they never record the promissory note.
Nope.
Because if they would have recorded the promissory note, they would have been helping your case out, and they will never help out your case. But also the fact that if they would have recorded that note into the public, that same entity, the public, would now hold the equitable asset and the debt title. And they would have merged the 2 titles in one entity, the public. They would have extinguished the debt themselves. They never do that.
No, they don't.
Do that.
Did you get that, Donna? I hope you're listening. Okay. On the 3rd page, the final page on my signature page on the note here, I've got this funny little stamp at the bottom. It says, paid to the order of Alaska Housing Finance Corporation without recourse residential mortgage. That's on my copy of the note. That basically proves that this is a negotiable instrument and that my mortgage has been satisfied, correct?
Yeah. And is there another secondary stamp in there in blank?
No, there's not another secondary. Well, there's a secondary stamp, but it was filled out by the senior vice president of residential mortgage, and she signed her name to it.
Okay, and then is there a blank where it says paid to, and then it's blank?
Oh, well, yeah, there was a paid to, and there was a blank line. But
okay, there's a double endorsement. The first one, they endorse it, whoever the beneficiary bank is, endorses it with the first stamp. And who was it again that endorsed it? You named it?
Residential mortgage is the ones that
okay, they're the lender, right?
Yeah.
Okay, they stamped it and endorsed it. Then they put a secondary stamp on another one just like it, except they don't put their name in it. And that turns it into a bearer instrument, and now they sell it.
Oh.
And now the holder of that instrument, that since there's no endorsement on that second endorsement line, it's blank, they're holding a bearer instrument.
Right.
Now, when they want to take and transfer to somebody else, they plug their name in on that blank line, and then they put another blank endorsement on there and pass it on to the next guy.
And there's your
and then they get paid.
Gotcha. There's the fraud. Well, more of the fraud. All right. So just with what I have here, I can prove that my mortgages have been satisfied if they want to take this to court. But I'm going to go ahead and mess with them. I've already got something of a rider created with trust terms in it. I'm going to move on.
Add on a UCC1 and do the UCC3, and then by definition, a trust receipt is a UCC financing statement of your note asset when you put it in the UCC, you've made it public notice and you've merged it in with the public debt security agreement and you've extinguished the debt. That's you lack the UCC filing, which is your receipt as a trust receipt of a record of a payment.
Right, which is exactly what I was thinking about doing, was what you just said, is put this new rider on claim it as mine and everything else, and then I can only file a notice of what I'm holding in the public. I can't file my rider in the public. I can only file a notice of what I'm holding, just like as if it was trust res. Correct?
Yeah, when you do a UCC with a notice of the note on there, then since they've already recorded the security agreement in the public, when you record the note in the public, now you have merged the debt with the asset and you extinguish the debt, you merge the titles.
Very good. Very good.
Now, the interest and stuff on the contract may be greater than the value of the note. That's something you have to worry about. But if you claim along with that note the application and the total documentation as a trust, now you're incorporating an unlimited equitable amount, your other signature on the application, that will pay all the other interest and whatever not's under the debt of creditor stuff that's greater than the value of the note.
Plus bring you back some extra quote-unquote money into your private trust account.
Yeah, and then claim the proceeds therefrom, which would be all the payments that you made, plus anything else that they've attached to those trust accounts and floated in any other bonds with it, and who knows what all they've done with it. Keeping good care of your special deposit, trust deposit, that you never knew was a trust. And you can thank them for that. Because
yeah.
they are taking good care of your trust assets.
Yes, they are. But they're getting the benefits of it because we fell down on our jobs.
Well, they really are only like taking fees off of it. The real principal and stuff should still be there. They don't breach their trusts. But now you can get it all back.
How much of a fight do you foresee your average Joe going through to be able to get it all back?
Well, we'll have to work on that. It amounts to, thousands of % over top of what was probably there put in. Who knows how many times the note's been sold? Who knows how many trusts it's been put into?
It's almost impossible to keep track or even know.
But all those funds are yours, plus all the things that they're attached to it. All the secondary debentures and bonds and things. We're swimming in a sea of debt.
Oh, absolutely.
Now, what we do is when we get that stuff back, we really can't put it back in circulation. We can't negotiate it again. We have to extinguish it. We got to get rid of it. And anyway, you only need a small fraction of it anyway to survive and live.
Exactly. Yeah, there's no need to be greedy here. I mean, we're already rich beyond our wildest dreams. We just don't know it and haven't figured out how to control it yet.
Yeah, I can create a negotiable debt instrument off my signature for any unlimited amount.
Right. Just like you said before, extinguish the national debt tomorrow and then, do it every day of the week.
Mm-hmm.
Okay. Very good. Well, I will plug in here on my my exercises and my studies. So thanks, man. I appreciate your help. I'll talk to you shortly.
All right. Nobody else? Well, if there's nobody else, I think we'll call it a night. For everybody attending the call tonight, and we'll see you, Monday. We'll see you Monday. Okay, we got 2 callers. Terry, you're unmuted.
Hey, Christian.
Hey.
I have another hypothetical for you. If you were in a position to acquire property with a home in a mortgage state, how would you go about doing that at this time? This would be a total cash sale, let's say.
Is there somebody in the property now?
Yeah, it's being acquired through a short sale.
So somebody's living in the house?
I don't think they're actually there. Let's assume they're not actually there.
If I wasn't buying it and then throwing somebody out, then something like that. How would I go about purchasing it, so to speak?
Right.
Use the NTT process and merge the titles. Put a claim on it so it's no longer abandoned. You'd probably have to do a quiet title to convey title. Get a conveyance.
And you can do that with a bank, for example, attempting to sell it on a short sale?
Yeah, you probably could, yeah.
Okay, let's assume you go the other way and you have FRNs that you're going to get rid of by making a purchase, a cash purchase. What would you do with it immediately after that purchase?
Put it in trust.
Into Inter Vivos Trust or a Private Express Trust? Or
at least an Inter Vivos Trust, yeah. Get it in trust right away.
Yeah.
Then I would concentrate on collapsing all the public trust stuff that was set up in the county and get it out of the county. And then once I got it out of the county records, then I would probably change that Inter Vivos Trust to a private trust. And there would be no records in existence of the house being recorded anywhere then.
And how would you go about doing that, getting rid of those records?
You have to go through the county and get rid of the records that were created there under that trust, collapse that trust, terminate that trust, and then change my Inter Vivos Trust around and put the public property, then put it in a private. And I'd probably do a allodial title and add myself onto the chain, and then that's it.
Okay. All right. And as far as the handling the quote unquote purchase in a mortgage state, what documents would you need to bring that about?
Just the UCC 1s and 3s and merger.
And then record those in the county, and that would be the record of a transfer of title?
As a payment, say, extinguishment of the debt.
To the bank that's
then you
selling
do a
it?
quiet title action. The conveyance is title.
Okay, quiet title action.
Yeah.
All right, and the UCC would be evidence that the debt was extinguished with the bank that's handling the short sale, right?
Yeah, let's back up one again. You might not have to do the quiet title. If you did the getting rid of the county stuff and pull it out, the private, pull out the county from the public and put it back into private, you might bypass the quiet title action.
So that would be all you need to do?
Yeah, because if you get it back out of the public, then that would be the main thing. Then I could do the allodial title. That way all the public trusts would be terminated. There'd be no other trust on it. It'd be totally private. Do the allodial title then. Yeah, once I terminate all the public trusts, I could bring the allodial title up and perfect the title then.
Okay.
And what were you saying about the bank?
I'm sorry, say it again?
What were you saying about the bank?
Getting it out of the title out of the bank's name with the short sale. That's how you
that's where I might need the quiet title action then.
And that would be something you record in the county, in the conveyance records.
Get it back into my name and then terminate the county one again. Because if I stick it back in a county after I got it conveyed in my name, I'd be creating another trust. But it's already in trust, and it's just a successive trust. But then I got to terminate that one in the county. So either I do it before and see how that works out, or I might have to do it after the conveyance on a quiet title action. See which one works out the better.
Whichever one they accept in the county?
Well, I think they probably accept it in the county, whichever way you did it, before or after. But I think the bank is going to be the one squawking.
Yeah. Well, let's assume that, you know, that short sale is conveyed to an individual, you know, through a purchase. And then you're sitting here with clear title to the property. Then in order to get it into a trust, a private trust, what would the process be there?
Terminate the one in the county.
By?
Merging the titles.
Okay.
Merging the titles, terminating that trust in the county.
And that takes it out of the jurisdiction of the county or authority of the county.
Exactly. Yep. And then you could bring a perfect title or the allodial title forward and perfect it by adding your name on it.
Okay, I'm not too familiar with allodial titles.
Yeah, that's what we had before 33. We had perfect titles. The trust came in and split the perfect titles, and now we have legal title and beneficial title. Beneficial titles always remained in the county since the first recording into the county, setting up a trust with the county as beneficiary. And we've been playing games all along all these years with the legal title, transferring the legal title from new owner to new owner.
Okay.
Privity of estate, look up that definition, Black's Law, which is a successive title transfer over and over again, same thing.
Mm-hmm.
That's all we're doing in account. Successive trust.
Okay.
But if we merge the title on that, terminating that trust, now we can come back and go back to the perfect title and add your name onto the last of the chain, perfecting the title with your name on it.
And that way the county would not be able to assess taxes or anything like that.
Right. Yeah, they can't do it anymore.
Wouldn't you have to go through a title search back to the original land grant?
Yes, to perfect and bring forward the perfect title, yes.
Right. Okay, that answers my questions. Thanks again, Christian.
Okay. Anonymous is up next. Yeah.
Oh, hi, it's Rick in SoCal. Just wanted to close up with word of positive things that have happened. Friday got a 4-week extension on my sale date, so instead of being sold Tuesday, I've got till September 14th now, and then I've got my lawsuit on the other side that I'm suing on the debtor-creditor side, suing them for RESPA and TILA violations. That the judge has given us an initial hearing of September 20th. So got some time here. It's going to start putting together the merging of titles and working with a couple of your TAs to help get everything processed and in order, so that hopefully by the time the hearing date, I can maybe do what you had suggested earlier, to merge my debtor-creditor lawsuit, which is with an equity hearing. So just wanted to give you some positive news and say thanks again for your work, and appreciate it, and just want to give you a positive heads up. So things are positive right now.
Okay, great.
All right, so you have a good night. Say hi to Lisa. Appreciate you guys.
All right, thank you.
You're welcome.
Marshall, you unmuted?
Hey, Christian, how you doing tonight?
All right. How are you?
All right. I'm doing all right. Kind of tired. I've been working a lot. I have a question that I wanted to ask you. First, there's a definition that I would like to read out of Black's 4, if I have it open. Are you familiar with civilita mortuus?
No, not. Go ahead.
Okay, well, it's something that I came across a couple of years ago, you know, during my studies with debtor creditor, and it's something that always stuck out in my mind. But civiliter mortuus in Black's Fourth is civilly dead, dead in the view of the law, the condition of one who has lost his civil rights and capacities and is accounted dead in law. Now, I read that definition because I wanted to ask you about nationalizing and how does it play into the role of trust, because I've read a lot of information. Now, of course, it's debtor creditor, that I can definitely admit, but I wanted to know is it important to actually claim a nationality, because I've read information that stated that if you don't nationalize, this is where this whole civiliter mortuus kind of comes into play, where you're not recognized by law. And what stuck out to me is the last sentence in the definition that says has lost his civil rights and capacities and is accounted dead in law. It didn't say at law or out of law, it said in law. And I just wanted to know, like, how does all of this play into trust? Or does it have anything to do with it?
Hey, we don't play the law part, so yeah, we want to be civilly dead. Because we're not doing any commerce anyway.
So that's a status that we would actually want to be civilly dead. Yes,
yes. We're gonna terminate the straw man. We're gonna become civilly dead. Now we've talked about dead all along. I never knew that was the term, the technical term for it. But yeah, we want to be civilly dead. We don't want to do commerce any longer.
Okay, so now that makes a lot more sense to me, because if we're extinguishing all of our debt and we're not discharging and we're in equity and we're using private assets, then we're not using any negotiable instruments, so we would have no use to be, quote unquote, alive in commerce.
Correct.
Ah, okay. That was something that always baffled me. So now let me ask you this. Now back to the nationality and the nationalizing. Do you feel that that's important?
Nope.
Or does it make a difference?
It just brings you back under the debtor creditor realm.
Right, right. Makes perfect sense. See, I was kind of thinking along those lines, but I really didn't know, to tell you the truth, because I know in debtor creditor to be civilly dead is something that you absolutely do not want. And I was figuring that to be, you know, different in trust, because I know in trust we're not dealing with statutes and codes and things of that nature, but I just, like, say on an international level, as far as trust is concerned, I just wanted to know if it had any bearings.
Dead means you can't do commerce, and commerce means you can't generate an income or make profits. But that doesn't say that you can't buy things or become a consumer. So we're going to consume, but we're not going to be generating a business, a profit that will effectively connect us back in with a business or trade. A business or trade is taxable and is commerce, and that gives you the civil nationality thing. And we want to be civilly dead, or on the private, operating through trust, just being consumers interfacing in to the public. Just so I can get those.
Well, you should see the big smile I got on my face right now, because this is something that I really was pondering over. I've been wanting to ask you this for a while now. It's just, you know, I have so many other things on my brain, but I just happen to be, you know, sometimes I just pick up Black's Law and I just start reading it, and I came to look up something. I forgot what it was, but I came across. It's civiliter mortuus, C-I-V-I-L-I-T-E-R, one word, second word, M-O-R-T-U-U-S, civiliter mortuus. And I came across that word, yes,
mortuary.
Civiliter mortuus.
That means you're dead civilly, yeah. Yeah, I never knew the Latin, yeah.
Yep, and Yeah, civiliter means civilly. And a person's civil character or position, or by civil, not criminal process or procedure. The term is used in distinction and opposition of the word criminaliter, criminaliter, to distinguish civil actions from criminal prosecutions. Now, like I said, I just wanted to ask you about that. So basically, it doesn't make a difference. We would want to be civilly dead because we are not operating in commerce. We will consume as real men and women because that's what we are supposed to do. But as far as operating in commerce and income and LLCs, so now hold on a second. Now, if we were to extinguish that quote-unquote Sedekey and the Foreign Situs Trust and we merge them and we still need in commerce, this is what we spoke about.
Yeah, we're going to terminate it.
Terminate. Okay.
Terminate the straw man trust account.
So, okay, yeah, I said extinguish, excuse me. So after the termination of that straw man trust account, we would need a public interface, which would be an LLC or something like that, that you know, stated many a time. So now, in that capacity, we're back in that commercial realm with an LLC. So
yeah, but we're not doing
we're
not doing commerce. We're just being consumers.
All right. So even though we have a commercial entity under an vehicle, we're still not engaged with our assets or the interests thereof from our assets.
Right. They're all private sourced. And we're just doing consuming. We're not doing commerce. We're not generating a profit. We don't have a business. We don't do a trade. We're not taxable. We're just consuming goods.
Right. Right. Okay, so now, all right, skip that topic. You said something earlier today that I wanted to ask you about also. You said if you're standing in front of a judge and you have your records, you have your NOIs and your SOIs, and, you know, a judge says that my records are no good for whatever reason, and he doesn't want to recognize my records, why? I heard you say that a little bit earlier. Can you elaborate on it just a little bit further on, like, what would be a response? Because lately you've been giving some good courtroom etiquette. I've been having to backtrack and listen to the calls because I kind of fell behind. But last couple of calls that I've listened to, I think it was 814 and 816 and I think 813. You were laying some things out. So if you could expand on that just real quick for me. As far as the judge saying, you know, your records are no good. Well, I know what to do if a judge was to say, I don't see a trust here. You know, you've been speaking about that since Gilbert's way back in the beginning. But this was the first time that I've heard you say a judge would look at you and say, well, I don't recognize your records or your records are no good to me. What would be a feasible response for that besides just asking him, why aren't my records any good?
Yeah, beforehand I would have put in the pleading that all rulings...
Because me personally...
All rulings from the court, I would have my pleadings that they should have in there that the rulings of the court should be made under facts entered into evidence and conclusions at law. And that way you got a way to go back in and ask them to put, you know, why it's deficient back to you in writing.
Hold on. Conclusion of law. All right. All rulings of court should be made under facts and conclusion at law, you said?
Facts entered into evidence.
Facts entered into evidence, okay.
And conclusions in law. So if you say my records are no good, I want you to tell me specifically, according to facts entered into evidence and conclusions of law, what law that you're relying on that says my stuff is no good. So I can go back and correct it.
Right, and you said this would go into. So you said this would go into your pleading.
So now I might want to change that
That's the first time I've
around.
heard you.
I'm going to change that around now that I'm thinking about it. Facts entered into evidence and conclusions in law. So I'm going to maybe put conclusions in equity.
In equity, right. You know what, I was going to ask you about that in law part also, so I'm glad you corrected that for me before I asked. Conclusions in equity. So all rulings of court should be made under facts entered into evidence and conclusions in equity, just in case a judge was to try to do something along those lines. So if that's in the face of your pleading and you attest to that, or, so that would be the procedure. But then, yeah, right. I kind of just answered my own question. Okay, so that right there would safeguard you against that type of a response from a judge. Okay, now skipping past that, the next question I want to ask you is something, again, that you said earlier, which was a bingo for me. Well, for me personally, you said if a person was to appoint, say, in a court action, the opposing attorney, if you were to appoint the oppositional attorney as your trustee in a matter, then that means that he say that again?
He can't be attorney anymore.
Right. That's what I'm talking about right there. That was a big bingo for me. And you know what? Whenever I thought about the attorneys, I always thought about, them not having any, first-hand witness. Everything is, hearsay. But I never thought of it in that capacity, that if one was to appoint the attorney trustee, then that strips him of his capacity of coming in as an attorney against you, like he works for you now.
Yeah,
so,
he's got a conflict of interest. He can't be an attorney and testify also at the same time on his own case.
Right, exactly. Okay, so now, if he was to disclaim, then a resulting trust is formed, and it is his duty now to appoint a successor trustee, correct?
Is he holding?
Is he holding?
Yes.
Res property.
If he claims and is still holding, then he is acting as a trustee, even though he disclaims. And we ran over an equity or a trust there, one of the books there in trust. I forget exactly where it is now, but it says that they can't do that.
Right.
They can't disclaim and hold.
Can't disclaim and hold at the same time. So that would be your res property then, right?
Mm-hmm.
Okay.
If the bank is disclaiming and they're holding, they're still acting as trustee. It doesn't make any difference what they say. Their actions speak louder than their words.
Definitely. Just as if we were to come into the courtroom claiming ourselves to be beneficiaries, but then we start asking questions about an alleged loan, now you're litigating and now you're acting as a trustee.
Right.
Right. I get it. Great. Those are kind of the only two questions that I had. I'll tell you one thing, Christian, that I would love for you to continue to do for me, and I know there's a bunch of people who would feel the same way, is to continue giving us your hypothetical verbiage of what one would say inside of a courtroom if an attorney or a judge was to say a certain thing to you, and what would be a great response, because people would be able to build off of that.
They need to take and come up with the questions that the judges have thrown at them, and then give them back to me.
And ask you about it. That's right. That's what I'm saying. Yes. That's going to make me take a couple of trips down to the courthouse and just sit in the back of the courtroom and listen to all of these foreclosure proceedings and, just simple traffic tickets or whatever the case may be, to just sit in there. And because now that I've been studying NTT, I haven't been in a courtroom many times, small traffic ticket that I had to deal with a couple of months back or whatever the case may be. But, I work with children and I work with adolescents also, and sometimes I would have to be in a courtroom, in a case manager capacity, and sometimes I sit in the courtroom and I would just listen to these attorneys talking to the judges, and when they're talking about bonds and they're talking about trustees and beneficiaries, but the language is so well hidden and it'll just fly right over your head if you're not paying attention to what's going on or even understanding the terminologies and the definitions that these people use inside of the courtroom is just amazing. So I think that's a very to take our doing to them, and like you said, run them back to you. Since I've been studying rules of evidence and civil procedures, sometimes I get on YouTube, and sometimes they have people's court proceedings and cases like on camera on YouTube, and you can sit there and watch it. And I've been doing that for the last couple of days, and I tell you, learning federal rules of evidence, civil rules of evidence for your local state or whatever the case may be, and civil procedures, like you were saying earlier, is so important, because affidavits and what rules of evidence say about affidavits would just blow someone's mind if they knew, like how powerful an affidavit is not, unless you are using it as far as making a verified claim about something, but not having the signatures under seal and the public witnesses. A lot of people bring their evidence in and they just bring it in the wrong way. They're not bringing in facts. They're bringing in hearsay. And I've read in our local, civil procedure that it states that if an affidavit doesn't come out in the courtroom itself, like in open court, it's like the lowest type of a record that you can have.
It's hearsay.
Yeah, it's hearsay, period. And, I tell you one thing, just throughout the whole debtor creditor realm and things that I've tried, I just thought the affidavits were just so powerful when you send in an affidavit and blah, 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 not even really understanding that in the courtroom is just, like you said, is a bunch of hearsay, and it's inadmissible.
The only power that's in an affidavit is on the private side. In
right.
chambers.
In chambers. I tell you, and like I said, studying the rules of evidence and, civil procedure, I really recommend that people, get into a little bit of that also. Like, definitely deal with trust and deal with equity, like you said, but we have to learn how to interface with these, these public officials and to give it to them the way they are, like, used to seeing it, as you were speaking about earlier. So I feel that that's very important also, and I think that's about it.
I forgot. I gave you that judge's description of how an affidavit should be put together, but also it goes with that, and I don't know if I gave it to you or not, but I don't think I did. It was the Henry Vargas case out of California.
No, I got the affidavit from you, and that affidavit is like the judge's, the thing that you sent me, big, very, very, very big, but I didn't get that case that you're speaking of now.
Yeah, write this down. It's Henry Vargas. I've got it if you can't find it. It's a bankruptcy case. Henry.
Henry?
Vargas. Henry.
Henry, like E-N. How you spell Henry?
I-N, second word, R-E.
Oh, Henry. Oh, Henry Vargas. Okay.
Henry, and then it's Vargas. It's a bankruptcy case, California bankruptcy case. In there gives you how they tore up the witness and his testimony and his affidavits.
Wow. Well, yeah, that outline that you had sent me as far as how to really put together an affidavit, that really blew my mind, along with the, like I said, studying rules of evidence and the inadmissibility versus the admissibility of your evidence. And because I remember a couple of months back, the first time that I went to the law library after speaking with you after a Wednesday call, that was the first thing that I went in to start photocopying. That very first time that I went after a good couple of years, it was all rules of evidence. Like, how do I bring in my evidence? Because the way we create our records using these UCCs and the things that we do with them is like they're very, very powerful, and it was important for me to know how to bring this evidence in correctly to make sure it is seen correctly and that it's, in the judge's face for him to see, because I feel that our records are very powerful, and if we present them to the courts in the right way, that, the adjudications will be in our favor. We would get our relief because we have the records that we need. And 9.5 times...
They're public records, and they're outside the hearsay rules. They're not in the case.
That's right. Yeah, so that, like I said, that was the first thing that I kind of dived into, which was the rules of evidence. So once again, I recommend that everybody get into your rules of evidence and civil procedure. It's very important. We can have all of the records and the UCCs and signatures under seals and certified copies. We can have all of that. But if you do not know how to bring it in correctly, all of your evidence will not get looked upon. And it's important. So I think that's about it. So Vargas, California bankruptcy case. I'm actually try to look for it in a little while, to tell you the truth. I really would like to see and read what they did to whoever you're talking about as far as their testimony and the affidavits. Because I tell you, a lot of people sending these affidavits thinking that it's doing some sort of a damage. I myself am guilty of it also. And to know what I know now about certain things, like I feel like, wow, really need to stay in these books and to keep understanding.
An affidavit is the lowest form of evidence.
It sure is. So I guess that comports to every state. Then it's the same, because here in North Carolina, it shocked my mind when I saw it. And like I said, I photocopied it, and some of my friends that I have who are like seriously still into debt accreditor, and just like I would show it to them, like, listen, look at what your affidavits are doing for you. Absolutely nothing when you send them in in the capacity that you send them in.
Yeah, the only thing they set up, if they're properly put together, is that it makes a prima facie case, and that's good enough to get you some kind of evidence attached to give you a case to support your claim. You need the support to support your claim. The support is your SOI. So your affidavit becomes your SOI, but it's just enough to get you in.
Right.
Makes a prima facie.
So okay. So now that we're speaking about the affidavits and that being your SOI, you need to have, it's obvious that we need to have by law, we need to have a verified complaint. Now, I don't know if I asked you this before, but I'm going to ask again because the answer is not really clear in my head. 9.5 times out of 10, whenever someone brings a bank or whoever brings a proceeding against us, or say traffic tickets or whatever the case may be, there will almost never be a verified claim. And without no verified claim from the actual plaintiff over that matter, now attack that.
That's probably 10 out of 10.
Say that again?
It's probably 10 out of 10.
10 out of 10. Yeah, basically. Yeah, I think 9.5 out of 10 was giving them the benefit of the doubt. So now my question to you would be, if we were to attack that from the onset, from the inception of any case, would that be showing in any way, shape, or form that we do have an adequate remedy at law? Because that would burst our whole chance of getting into equity correctly.
Right. Yeah. Because you're going to challenge the jurisdiction of that law side.
Really? So that's right. So that's something we definitely don't want to do. It was that I spoke about this before. No, it was Eric and I who spoke about it. That's why it sounded a little familiar to me. And yeah, you basically confirmed the same thing that we had said to each other. Like that it can be construed as you having an adequate remedy at law. So one does not want to go that route.
You know, if you look at it, you're challenging the court, and when the court, if you get them they don't have jurisdiction, then where's your court of equity? If there's no claim against, because the court doesn't have jurisdiction, then why do you even need a court of equity?
You don't need, exactly. Right. Okay, so that's definitely a no-no. But I'll tell you one thing. That's a very, although I'm not into the debtor creditor, I'm like 100% NTT. I tell you one thing, that is a very powerful at-law tool. If used correctly, it can really get some results.
Because we have won a case using that method alone.
Just that method alone, that's right. That is a very powerful at-law tool that can be used if you not well-versed in trust and knowing how to, deal with NTT. That's a very powerful thing right there.
It comes back to what I've been saying all along. You can win solely at litigation, which is the at-law method. You can win solely by litigation, knowing what we know today, and you should be able to win that way also.
That's right. I believe so, too. I just don't feel like going to play basketball on the football field.
That can stop your immediate proceedings, but it doesn't cure your overall problem. And that's what NTT would do. It would cure your overall problem as well as your immediate one.
That's right. So it's liking to a situation where I was listening to a lady on a call. I don't want to mention her name, but I do know who the lady is. And she was speaking with you, and they won a foreclosure case, but they had the case dismissed, I believe she was talking about, but then did not get the full remedy or quote-unquote relief that they were looking for. But so, like, how can that be if the case was dismissed with? Say that again?
It didn't get dismissed with prejudice.
Okay, it didn't get dismissed with prejudice. Yeah, I was listening to that call earlier today, and I said, wow, how can it get dismissed? But then again, there's still elements within the pleading that the judges or the court did not honor.
They left the door open for the in due course to come in and do another foreclosure action.
And do another foreclosure. That's right. Whoever is holding that equitable title would still have an opportunity to come back in and start another foreclosure proceeding. So that was, in a certain ways, a temporary fix for right now. Now, the next foreclosure could probably commence years later. I mean, but yet and still, it's coming sooner or later, basically, right?
Yeah, you might as well count on it, yeah. You better get the property put into an individual's trust and get it pulled out of the county and get it put on the private side, or else you got problems coming up.
Right. Now, on another call, I see this is what I'm going to be doing. I'm going to listen in the past calls that I haven't heard and asking you about them on the present calls. I heard you mention that an allodial title has 3 parts to it: possession, right to possession, which is the real title, and then a right to real property. Did I hear that correctly?
Yeah.
Okay, see, now, I was under the impression that the allodial title was just the perfect merger of the equitable title and the legal title, or is one or two of these facets?
The merger just puts back to what it was before it was split.
Before it was split, okay.
Split the title, and when you merge and terminate the trust, then you put back what the trust created, which was 2 titles. But now you can't bring a an allodial title forward because the trust is blocking it, because it split the title.
Right.
You got to terminate the trust, and then you can bring the allodial title forward and put your name on it and add it to the chain.
Okay, so if we have only two titles, equitable and legal, but then the description or the survey within this allodial title has three facets to it, like I said, possession, right to possession, so then that means one of those titles would have a dual, a duality going on.
Right. So here's how it breaks down. The right to property is the beneficial title. The right to possession is the legal title. There's your two trust titles. And then the third one, which was the first one in the chain, the possession.
Possession, yeah. So possession would also go with the equitable title also, right? Or is that the legal title?
Well, no, it's not until you combine all three into one that you've got a perfect title.
Then you have true possession.
Yeah. So it's the right to possess and the right to the property. You merge those two, and you can perfect the title. But you could be owner of those and have the right to possess, but then somebody else could be living in your house.
Yeah, absolutely, absolutely.
That party has possession. That's a third party. That's why they're split in three. Possession is one, that third party. Right to possess is another title, legal title. And right to property, that's beneficial interest or beneficial title.
Right,
but
right.
Perfect title, you got to have at least those two.
Absolutely. Okay. Okay, so now, past the titles now, when it comes to your bill in equity, would it be enough just to speak of a breach of your right to possession and your right to real and or personal property? Would that be enough, along with, a couple of the other switches in there that you always talk about?
Yeah, those are equitable rights, yeah.
That's right. So all you would need is, say, one or two. It doesn't have to be 12 pages, and I've seen some pleadings up to 30 and 40 pages.
The judge ain't going to read all that. He's going to fall asleep after the fifth month.
That same thing I said to myself, who's going to read 40 pages worth of a pleading? Not saying that the stuff that's held within inside of it or the corpus of it is not relevant, but wow,
yeah, well, if you have 12
40 pages?
If you've got 12 rights that have been breached, pick the top 3 and throw those in there and forget about the rest, because you ain't going to have time to talk about them.
And that's all you need. That's right. That's why I asked you what I just asked you, because, your bill in equity could be, like how Chris was talking about a little earlier, a one-pager, probably. If you put it together correctly, 1 page, and that's it. And here we go. We're off to see the wizard. All right, cool.
Our deficient paperwork, yeah.
Yeah. All right, that's cool. I think that's about it for right now. Okay, so we definitely don't want to go the unverified complaint route unless you're versed in just, at-law litigation and things of that nature. Other than that, I'm sticking with NTT and the trust, and that's just it. Oh, the 3 trusts in real estate.
Unless you want to create 2 actions. You're in court on their action, defend it with litigation, and then come in and hit them with an independent claim being trust. Totally independent action.
Oh, wait a minute. Whoa, wait a minute. You can do that?
Yeah.
I knew we could control both sides of the court on the public and private, but I thought they would have to been enjoined somehow. They're completely separate. No counterclaim, no nothing. So I can come in and answer a complaint that may be brought against me and then turn around and file a whole complete separate complaint against you.
Yes, on some new ground, some other ground.
On new grounds. Wow. Okay, see, that's another bingo for me. I appreciate that. I love options.
People don't know their rights. They've never done this stuff before. They're perishing for a lack of knowledge of the rights.
Is it rights, Christian, or is it procedure?
Yeah.
Well, you know what? People don't know their rights either, to tell you the truth.
Yeah, I know. It's really pathetic. We're our own enemies.
Yeah, absolutely. Absolutely.
We're blaming them. No, it's their fault.
Wow, that was big. That was big for me. So you get a chance to litigate at law and to also be a beneficiary in equity. Nice.
And you
nice.
combine the cases and just do the equitable hearing on a counterclaim. And then if you lose there, you got your counter. You got to litigate the other one.
Right. Exactly. See, that's the model that I'm more familiar with. You just encompass everything within one equitable pleading. I have no adequate remedy at law at all, so we need to talk about this in equity. See, that was the model that I know of, but to have two completely separate actions at the same time, where I can, if one is well versed in at law proceedings and I know civil procedure and rules of evidence like the back of my hand, like, yeah, I can do that, but then again, I can also do equity and just come in under trust.
Yeah.
Well, the only thing that would make it, because like I said, I'm like 100% NTT, but the only thing that would make the whole at-law side feasible in any way, shape, or form is just the fact in the very beginning, like we said, 10 times out of the 10, they will not have a verified complaint. And if you know how to attack that, you'll be in that courtroom every bit of 5 minutes. And if you do it the right way, you probably won't even make it to court if you motion the correct way.
Well, as we were talking earlier tonight, I forget who it was. We were talking to Chris or maybe somebody before him. We were talking about the two sides of the public and private, or the equity versus the public.
Yes.
And really, you don't need the at-law stuff, and you shouldn't get commingled back into that at-law stuff. And it's really simple, so that if you understand it, because it's really simple. You only got 10 maxims or so.
That's right. That's right.
And if you understand that they can't talk about anything in their pleading or anything from the at-law side, because equity can't hear that because it's at-law, only unless you open the door for it. So if you don't put any of that stuff, at-law stuff, in your counterclaim to hear in equity, it shouldn't be heard.
Right.
And you can object right away.
Right.
And we can't talk about that stuff because it's not in my pleading. And we're only here to talk about this hearing, what's in my pleading. And if I've only got equity things in my pleading, we're here just to talk about the equity things and what's their answer to my equitable claims.
People would have to know how to stand on that. I was listening to a call, I think it was yesterday, where Eric was on, and he was stating that, we would have to go into these courtrooms and know how to stand in equity and stay there, because a judge will test you. He may do the 3 strikes rule against you. He may threaten you with contempt or 30 days in a county lockup or something crazy like that.
Plaintiff is going to ask you some at-law question, and then what he's going to ask you is, yeah, but Your Honor, we got a debtor-creditor contract here. He owes us. Well, you should be objecting right away.
Right away, absolutely.
At-law stuff, and where's that? My pleading here. We're not talking about that today. We're talking about a trust. We're talking about payment was made through the trust, or he's in breach of trust, or something about the trust.
Right.
And that's thing we're here to talk about today. Nothing about plaintiff's debtor-creditor contract. That's equity. That's standing your ground in equity, and you can do that.
That's right. That's right.
That just shuts plaintiffs' at-law side down.
Very much.
Closed them down. All the public policy, all the statutes and codes, closed it down. Stick to the maxims in your counterclaim or your motion for a hearing.
Yeah. So I
Don't
guess
bring
it's
any
just
out. Don't talk about it. Object to it. Don't have
the
to answer
intimidation. Yeah, it's the intimidation factor that people would be feeling standing in front of that black robe. That's what it is, basically.
Yeah.
And,
well, the strength comes in the fear is overcome by the knowledge, and you don't know the knowledge because you don't know your rights. You don't know what you can do, what process you can do.
Absolutely. So now, what about the attorney and the whole entire hearsay? You were not there when this private trust was formed. You have no firsthand knowledge. Is that claiming another at-law remedy that would burst your chance of getting into equity?
Depends what
I
the
think that's
question
kind
was.
of a fine line right there. To me, that would be a fine line, because knowing something like that, like to know that, okay, the attorney wasn't there, he's testifying, he's not a competent witness, he has no firsthand knowledge, every syllable that comes out of his mouth, I'm going to object. Now, that would be...
The only thing he can say is exactly what's in plaintiff's motion, verbatim. Anything other than that, he can't say anything.
Right. So now, if you were to continuously object to this attorney because of, say, the hearsay, and like you just said, if it's not within the plaintiff's pleading, there's nothing that he can do or say about it. So if you continuously object to whatever he says, would that be exercising an at-law remedy?
Well, no, he's not a competent first-hand witness to give any testimony counts to anything.
Okay,
whether
yeah, but I know
at law or at equity.
Oh, all right, because I know that the hearsay is a statutorily based remedy that one would be able to use, because they use it against us, and we would be able to use it against them also.
Sure. Yeah.
Okay, I just want to make sure that one would not be traversing back into that at-law pleading and arguing of facts and things like that and blowing your whole chance, because the hearsay thing, it's... Discovery
is equitable.
Discovery is equitable, okay.
And discovery what? Evidence. What's evidence? Well, testimony. What's testimony? Are you competent? Are you incompetent?
Right. Okay, so that basically falls right under the evidence rule, which takes it kind of out of having to worry about traversing and arguing facts, because this is evidence we're talking about.
Yeah, you can't give testimony if you weren't there. You're not a credible witness.
That's right.
Wait a minute, I object to that. This guy can't say one thing. He wasn't there.
Absolutely.
What tell me if you were not there about this case?
Right. Right. Well, I'll tell you one thing. I'm going to be talking with a couple of my friends, because I'm sure going to come up somehow with a list of questions that I think a judge, because, you know, it's the application. We have the doctrine. We've been, you know, indoctrinating ourselves with NTT for a long time now. Like you say, now it's time for the practice. And when you go in there, you can know the things that you need to know, but may not be fully prepared for the tricks and the traps that they may set, and how easy it is to get you to set your own judgment aside or to lose equity while you're in there. I'm going to give you the republic, now keep it. It's like, you know, that type of situation right there. So just hypothetically speaking, I'm going to definitely, come up with 5 or 6 questions to ask you as far as what would be a great response in responding to a judge or a magistrate or whoever it may be.
Right, yeah.
All right, well, I think that's it for tonight, Christian. I appreciate your time as usual. Thank you for talking to me. You gave me a couple of bingos tonight, and I got some things enlightened and clear in my mind now as far as direction, especially the 2 separate action. I wasn't thinking of it in that matter, but like I said, I'm NTT all the way. I appreciate your time, sir. Thank you.
All right, well, thank you all for joining me tonight, this Saturday. So we'll see you on Monday on the Monday Night Show. So everybody have a great weekend.